All right. Good afternoon, everybody. I'd like to call to order the June 1st, 2016 meeting of the Sunshine Ordinance Task Force.
On the call of the roll, Member Eldon.
Aye. Here.
Eldon present. Member Wolf. Wolf absent. Member Copra. Copra absent. Member Tesfaye. Here. Tesfaye present. Member Bruce Wolf.
Here.
Wolf present. Member Moss.
Here.
Moss present. Member Kanata.
Here.
Kanata present. Member Fisher. Fisher absent. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland.
Present.
Hyland present. We have a quorum. At this time, I do not have any agenda changes. At the chair's convenience, vice chair's convenience, would you like to introduce the new members? Have the new members introduce themselves?
Sure, that'd be good. So why don't we just go around in order of the roll call, and if you could announce each person, and just give us, maybe 60 seconds or a couple of minutes on your background and why you're excited to be here today.
The first on the roll call order was Member Tesfaye.
Hi, everyone. My name is Luam Tesfaye. I'm very excited to be here. I'm in seat 5, so I'm on the board of the League of Women Voters of San Francisco. My background is I'm an attorney. I practice at the Public Utilities Commission, the State Public Utilities Commission, as a legal advisor right now to Commissioner Randolph. And I do a lot of California Public Records Act law and open meeting law, and so I'm excited to bring that expertise here. Thanks.
Wonderful. She said the A word. That was good. Next.
Next on the roll call list would be Member Moss.
Hi, my name is Dave Moss. I am
No, go ahead. Please continue.
Thank you. My name is Dave Moss. I am an investigative researcher at the Electronic Frontier Foundation. Before coming to EFF, I was a journalist, but both as a journalist and at EFF, I file lots and lots of public records requests around the country. So I'm very excited to be here and use my expertise in that capacity and to serve the city and county of San Francisco.
Thank you.
Next on the list would be Member Bruce Wolf.
Good afternoon, everybody. This is a return for me back to the task force after a hiatus, 4 years. I served 7 years prior to that, and it was a very fruitful time in a lot of ways. So I'm glad to be here with the support of the community and the previous members, outgoing members, retired members, and hopefully have a really good time and make sure everything stays fair and balanced.
Don't you have someone else to introduce?
Oh, and Lady's with me. Actually, this is
superstar.
her first. I think this is kind of her first time
Under the dais?
on this dais. This is my
Very good.
Yeah.
All right. Welcome, Member Wolf.
Thank you.
Next on the roll call list would be Mr. Kanata.
Hi, I'm Frank Kanata. I'm in seat 8, which is one of the community advocacy seats. And my experience is I was a co-founder with my wife 11 years ago of the Middle Polk Neighborhood Association, and we did a ton of work throughout the city in all different facets: crime abatement, cleanliness, planning and development. And to me, the Sunshine Ordinance, to me, seems to be the contract between the general public and the city government on how the government is run and how the residents of the city have access to how the government is run. So I'm excited to be part of it.
Wonderful. Welcome. So that was it, the 4 new members, is that right?
Yes.
All right. Looking forward to it.
Next on the agenda, item number 2, file number 14095, complaint filed by Bob Plantold against Supervisor Malia Cohen and Supervisor Scott Wiener, Board of Supervisors, for allegedly violating Administrative Code, Section 67.7 and 67.15A, and California Government Code, Sections 54954.2 and 54954.3 for failing to provide adequate opportunity for public comment at the Land Use and Economic Development Committee meeting of September 15, 2014 and September 29, 2014, and the Government Audit and Oversight Committee meeting of September 11, 2014. The task force has previously heard this matter on January 7, 2015. The matter was continued to the call of the chair pending an analysis by former member Rumwold regarding the definition of a substantive amendment to legislation.
Mr. Chair?
Yes.
Just a point of information. Wondering if there are any minutes that have to be approved and should be approved before any new business or any business should be taken. I don't know if that's been a matter of course.
We usually do it towards the end, and we probably should have recognized that in agenda changes at this point. But that's certainly something, food for thought for future meetings.
Generally to
Tidy housekeeping.
Approve your minutes from the previous meeting means that your meeting is over and you can start a new one.
Yeah, good point. All right. Mr. Clerk, please make a point of that, and perhaps we can do that for next month's meeting.
It's at the task force's discretion. Previous discussion by this task force, they decided to move towards the end of the committee due to public comments stating that approval of minutes was taking away time from comment on complaint. And the task force at that time did decide to move the approval of minutes to the end of the agenda. If you would like to change that practice, please let me know and I will do that.
Yeah, we can talk about it more at the end under announcements.
Okay.
All right.
Thank you.
And Mr. Clerk, do you have some background on this particular file?
This matter was previously heard and continued to the call of the chair. I believe, to summarize, the committees at that time heard matters, took public comment, and after public comment was taken, they made additional amendments and did not take additional public comment on those amendments.
So you're referring to the supervisors?
Yes.
Okay, all right.
And then Member Rumbold agreed to review the matter. And I did provide additional information in your packet regarding the requirements of the code. And from my understanding, the determination of what is a substantive change is determined by the legislative body themselves. And I believe that the Board of Supervisors defers that function to their city attorney.
Okay, that's standard practice. Okay. So we don't have to find jurisdiction, but we can go ahead and...
We can move directly into discussion.
Okay. And I see Mr. Plantold is here, so I'd certainly welcome some insights from him. Maybe we can start with that.
Would you like to allow 5 minutes for Mr. Plantold?
Certainly, yeah.
I'm Bob Planthold. First, there's some procedural questions I want to raise with you folks. When then-member Rummold said he would write a memo, it never happened while he was a member. I commented on that at a later meeting. He subsequently came back on the task force, but again, while he was on the task force, did not submit the memo. What came now is from a private citizen, if you will. And that may be relevant because you're referring to member Rummold, and it's not. It's just a guy, for however you want to consider that. Now, I want to go to the issue of the public comment. It's not just whether or not it's substantive. David Chu was the one who made the changes recommended, though he's not on the committee. Supervisor Wiener on that committee like Chu, is an attorney. They're very careful with words. They're not sloppy. They're not slipshod in their wording. So it would seem that then Supervisor Chu did have in mind what he wanted to do. This was a response to the grand jury. I'm a veteran of 4 grand juries. Those can be very forceful in trying to find out the response and how you can hold accountable a department. What's been ignored is that technology is something that's a factor here in public comment. I was part of a group called Friends of Ethics that was dealing with some of these matters. One of the people in it was on the grand jury that wrote that report, but he wasn't in the room. That person texted people with comments because you cannot call into the SOUPS meetings unlike the Disability Council where you can call in public comment. But he could have texted in if the public had known in advance that Supervisor Chu wanted to make these changes. And then one of us during public comment could have said, we like it, we disagree, we don't understand. And in that sense, public comment was thwarted. Whether or not you want to accept A, that it's substantive or not, B, there was this denial of public comment because there was not a consideration of technology being a factor in communicating from the outside world into the committee hearing room to members of the public. That's what's been overlooked. That's what can be relevant. And I'm also going to say, you may think it's common or standard to delegate the decision on what constitutes significant to the city attorney. That's not an automatic. That's not a necessity. And I'm suggesting here again, you may not have jurisdiction, but as there is an education committee, it may be worth having that committee explore what's the rationale why the city attorney would determine, because I can see a multitude of situations and scenarios on matters dealing with the city's Public Utilities Commission, Public Health Department, Public Works, contracts of any nature. What is substantive? Is it dollar change? By how much percent? Is it, as you'll hear in the second complaint, I think there is substantive changes going on sometimes that get overlooked in the rush. You're here not to help make supervisors' work easier. You're here to help make the public readily aware of what's going on in government, have access to the information, and be able to participate at least through public comment. So that it makes it easier for the soups, sorry, that's not your job. You ought to think about us out here. With that, if you've got any questions, I'll answer them. Otherwise, I'll just wait.
Great, thank you. Is there anybody from the respondents' side here today? Please approach.
Good afternoon, members of the Sunshine Task Force. My name is Brian Halipa, and I'm here on behalf of the Office of the Clerk of the Board. I'm not actually here to represent any of the supervisors' offices, but I am here to speak on the facts and details on record regarding the file. As a refresher, this file is a matter that was already discussed in exhaustive detail by the task force at the January 7th, 2015 and the February 4th, 2015 task force meetings. For background, on October 8th, Mr. Planhold alleged that then President Chu violated the public comment requirements in the Brown Act and the Sunshine Ordinance when he proposed and voted on amendments to a resolution at the GAO meeting on September 11th of 2014. He similarly alleged that then President Chu and Supervisors Cohen and Wiener violated the same public comment requirements when they proposed or voted on the amendment to an item at land use on September 29th of 2014. The complainant's allegations and assertions are incorrect. As far as the Brown Act and Sunshine Ordinance is concerned, they do not require distribution of the text of proposed amendments before public comment, and the amendments adopted at the two hearings did not require additional hearing for public comment. The respondents, Supervisor Cohen and Wiener's offices, had already provided numerous responses and rebuttals per the minutes, and I believe also in your packets, you could read that. Public comment was taken at the SOTF meetings, and Nicholas Kalla, Deputy City Attorney for the task force, also provided his comments and input at that time. This item on the last SOTF meeting was continued to the call of the chair as the clerk had said, for SOTF determination, pending then Member Rummold's analysis regarding what was considered to be substantive as it relates to the amendments to legislation at BOS and requirement of the Brown Act and Sunshine Ordinance. Then Member Rummold recently affirmed in his draft findings, also found in your packet, that an item is considered substantially changed when the board so determines. He further determined that neither the Sunshine Ordinance nor Brown Act were violated. within the parameters of California Government Code, sections 54954.3, subsection A, and Administrative Code, section 67.15, subsection A. It is the legislative body's authority to determine the timing of public comment on agenda items. The precise timing of public comment is at the discretion of the legislative body, and there are good policy reasons not to circulate proposed amendments until after hearing the public comments and ideas. The alternative rule, requiring supervisors to propose any and all amendments before the public has offered its input, could and would result in an unending cycle of amendments, followed by comment, followed by amendments, followed by comment. There is no new information or findings to provide on behalf of the respondents, as all the facts have been already presented. We are simply awaiting the SOTF's determination based on the information already provided and Member Rummold's recent supporting findings. We urge that the task force to expediently reach a determination. The complainant's premise is simply incorrect as a matter of law, and the allegations are without merit. Thank you.
Thank you. So just for the new members, what we do now is we discuss the case. We invite public comment. We make a motion or don't make a motion. That's the general order. Is there anyone like to start us off?
I will.
Member Wolf?
So I have a couple of questions, because now after reading the packet on this and hearing some of the testimony, I've got some clarifying questions. Can I ask?
Please.
Mr. Planthold? My first question is I am reading from your original complaint, and then throughout the back and forth that you've had with staff. Was this general public comment that you're referring to, or was this public comment on one or each of the amendments that was being introduced?
There was no call for comment on amendment by amendment by amendment, or on anything. It was a, if you will, gang call. Here's what we're proposing based on the written text put out to the public. What do you think? And after that was closed, then the amendments were made orally.
I'm sorry, repeat that one more time.
So the call for public comment was on what had been put out to the public in print and proposed that was online. Only after that public comment was closed, then were there the amendments proposed by then Supervisor Chu.
So again, the public comment you're referring to is general public comment?
Yes.
Okay.
Well, it's on the item, item on the agenda.
Okay. So the process, and I know you know this, I'm just trying to get clarification. The process would be somebody introduces a motion, it gets seconded, then you have public comment.
That's not the way typically many supervisors' committee hearings work. They call an item, they'll have a staff report, they'll ask for public comment, then maybe during public comment, maybe after close of it, then there will be some discussion and a motion made. Okay. Typically, a motion is not made before public comment.
Right. So did they call public comment at all?
Yes, as I said, on the general item.
Okay. But not on the amendment when it was introduced? No. Okay. And so then the question becomes, was the amendment, in your mind, substantially, would have it substantially changed the motion that was already on the floor?
It could have, but you see, I'm trying to get you folks and all the other interested parties to think. We heard a statement that there's no requirement that amendments be proposed in advance, that it would be burdensome. So what if there was a budget hearing, and after public comment, then a motion was made to cut the proposed budget by X department by 90%? That's an amendment. Public comment's closed, and you're gutting that department. So the very idea that you don't have to propose amendments can have fact situations that show it's ludicrous. And again, I'm saying because Chu was an attorney, Wiener was an attorney, you'd think they'd have knowledge of what they wanted to do. I didn't say, as could have been inferred from what the rep of the clerk of the board said, I didn't say public comment on each amendment. That's burdensome. That's seriatim. But if there were going to be amendments, they could have announced at the beginning, we're considering amending this section in this way. We're considering amending this section in this way. Just a general announcement to give folks a heads up tip off.
I understand.
That didn't happen.
Actually, the ordinance is very specific on this and directive on this particular point when amendments are introduced. There are 3 areas. If a agenda was posted and there were to be amendments introduced before the meeting had commenced, then there's a process for that. If the meeting had already started and somebody wanted to introduce amendments, but before the item was called, there's a process for that. And then lastly, as I think what you're typifying is after the motion has been called to the floor, that an amendment would be introduced, and there's a process for that. The question is whether the amendment had a level of substantial change in it or not. Whether or not the Board of Supervisors determines it or not. Despite that, in general, the question is did any of those amendments provide any substantial change to the motion that was already on the floor or to the motion that it applied to?
I think it could have, but I want to differ with your characterization that my framing is of the third option or type of the amendment raising process, because the documentation there indicates that Supervisor Chu had and distributed paper copies. That meant it was done beforehand. And at the same time, again, because there weren't enough copies, I didn't get to see a copy, others didn't get to see a copy, and so those whom were texting us didn't get to see a copy.
You're saying that the amendments were made by another supervisor not on the committee.
Right. Because he was president of the board.
And he texted members of the committee?
No, I'm saying what I said earlier, there were friends of ethics, my group, who were texting some of us in the room.
Got it.
With questions or suggestions.
Got it.
And so they outside didn't have a copy. I didn't have a copy. And again, Supervisor Chu, according to what your documentation there says, had paper copies printed and distributed in the room. So it wasn't an after-the-fact closing of public comment when this surfaced. It was beforehand, but I didn't know it. Others in the public didn't know it.
Okay. All right, thank you. And a question for the representative from the clerk's office.
If you don't mind, I'm going to stay here just to avoid fatigue getting up and down.
Sure. Actually, Mr. Clerk, as he approaches, is a remote microphone a possibility for future meetings when we have ADA members?
I will check with building management.
Okay, thank you.
This is the protocol microphone typically used, Mr. Vice Chair.
Yeah. Be nice if there's one that could be brought to you, right? Yeah.
I'm sorry, I didn't catch your name.
Brent Halipa.
Brent Halipa, nice to meet you.
Likewise.
So my question for you is you stated that the city attorney or legal counsel for the Board of Supervisors had determined that the Brown Act and the Sunshine Act were not violated, but you didn't state whether they found that the amendment or amendments that were introduced at this meeting were of any substantial change to the motion, to the original motion.
Well, I can't really speak on, on the determination itself.
But that's the basis of your defense here.
Well, no. The thing is, our defense is that within the parameters of the government code, and Mr. Planthold's allegations, there were no violations.
Well, but his allegation is there was public comment.
Yes.
Was closed before the amendments were introduced.
No, well, as far as the code itself is concerned, is that we just provide public comment as the item is being considered. And the item is in consideration until an action has been made on it.
That's not actually the way it goes. If you have a motion on the floor and you have somebody moved it and seconded it, and then they open it up for whoever needs to testify about it, and then they open it up for public comment. And then after that public comment is done, somebody says, you know what, I got a bright idea from all that discussion, and I want to make an amendment. So now they introduce an amendment, and that amendment has substantial effect.
Sure.
Okay? Another round of public comment must happen. The public has a right to speak on that item.
The thing is, if there is a change on the floor that is deemed substantive enough by the members of the committee and or the deputy city attorney, it would have to be continued and re-agendized, and then it could be heard.
Right. So that's my question to you: is all you testified here today was that the Brown Act and the Sunshine Ordinance was not violated, but you didn't really answer the question that that's based on. The question is has there been an official determination that these amendments that were introduced were not substantial, did not substantially change the motion on the floor, and thus if they weren't, then fine, you're absolutely, in your right to do that. But that question needs to be answered.
Right. And I personally am not in a position to answer that question.
So when you said that, I'm sorry, I'm not leaning into you, but I'm just trying to get clarification. When you state that the city attorney or the legal counsel for the board has stated that there was no violation, on what basis did they say that? You can't just say it. It has to be brought with some evidence that there isn't. So if they say that it wasn't violated, has to be some explanation as to how it didn't substantially change things.
Okay. Well, to that
That's
question,
the end of my questions.
Okay.
So please answer.
Oh, no, I mean, just to that effect, I mean, I'm mostly going off of record in that there was no, there were no objections, like the deputy city attorney did not raise the fact that we're moving into substantive changes or substantive change territory, and therefore that's where, I get my assumption.
Okay, thank you.
Mr. Plant, hold on 1 second. Member Cañada?
Yes, I'd like some clarification. Mr. Planthold, did I hear you say that Supervisor Chu had this amendment already printed out in limited quantities and some people had them?
That's what's indicated in the material in your packet, that amendments were distributed.
Okay. And does the respondent, I'm sorry, I don't remember your name.
Brent DeLupa.
Okay. Do you know if that's true? If this amendment was already written out and copied and distributed in limited quantity at the meeting?
No, I'm sorry, Member Canada. I wasn't there. Okay. Yeah. Let's see. But there is record of the meeting. Let's see. I'm sorry, Mr. Clerk. Where's the record? Is it by audio or video of the meeting?
There is a video of the meetings maintained on the SFG TV's website.
Okay. And the reason I'm asking is if in fact the amendment was already thought out and printed out, why would they have public comment on the issue without the amendment being part of it? Because it doesn't sound like it was an amendment due to public comment, from what I'm hearing. So,
perhaps Member Wolf might have some more institutional knowledge on what took place. I mean, we're talking, several years ago. This is a fairly publicized case.
Yep.
I like the angle that Mr. Planthold's bringing to it. Interesting one. But as far as what didn't happen, I think that's a bit of a slippery slope at this point. I think what we have to do, like you're doing, is just focus in on the ordinance. And my instinct right now is this might be something we continue and have someone that is more knowledgeable from the respondent side appear in front of us. No offense, but this is a pretty serious I guess, landmark case in our history of Sunshine, if you like. So this might be something worth putting aside and moving on. That's just my initial take, but
Mr. Chair, I would agree with you. It was actually going to be my suggestion, was to continue it and find out what that answer is. And also then I'd like an opportunity to review the video. I actually did not do that. That's actually a good idea. So actually I can see what's happening and then take some of the additional points that were made with regards to, was the process with regards to how the ordinance directs how amendments are introduced, was that followed properly? And so I would like a little more time to review that.
any other members have any input? Yes.
This question is for members here, or if you cannot respond, perhaps the clerk of the board can answer this question. Is there, at this time, a way for amendments from the dais to be projected onto a screen for the public to see in the event that there aren't enough copies? Because you never really know how many people are going to be present.
Mm-hmm.
The overhead display in the clerk of the board's room is only one page. There's no way to display the entire document, as it can be hundreds of pages long.
Sorry, what was the last thing you said?
Amendments
that's not
legislation can be hundreds of pages long. There's no way to project the entire document for public view on the monitor, as there can be hundreds of pages. It could be 1 or 2 pages, or it could be a few hundred pages.
And so the Board of Supervisors would potentially be reviewing hundreds of pages of amendments on the fly?
It can vary,
Okay.
depending on how they present it. They can just provide a summary. They can provide the entire document with cross-out and add-ins and so forth. I speak from experience and not as a representative of the clerk of
Thank you.
the board.
And just to second that question, that technology was in place in September of 2014?
Yes.
Okay.
Basically, what we have in this room: overhead display and
Gotcha.
computer
Okay.
display.
Okay. I remember Mr. Plantold, he had some comment on this.
I just wonder, with regard to the video, realize it's a fixed focus system focusing on the dais. So you're not going to get information of seeing somebody walking up and putting documents on the lectern for the public. You're not going to see any of that in the room of people walking around handing out documents. I mean, you may not be able to discern whether or not there are documents made available to the public. All we know is they were distributed, maybe just to the supervisors on the committee and their staff and the clerk and the city attorney. It's unclear. And don't assume the videotape will provide all of that clarity that you may want.
Agreed. Thank you. Why don't we take some public comment on this item at this point? Thank you.
My name is Francisco da
Give
Costa.
me 1 moment. Sorry. Okay, please begin.
My name is Francisco da Costa, and I've been attending the Sunshine meetings forever. Today, while I was here, I just saw you, Chris Ireland, being sworn over there, while the people who were in this room did not know what was happening. And I say that we have to take every swearing seriously. Now, having said that, I personally know that attempts were made by the Board of Supervisors and others at City Hall to destroy this task force.
Mr. DaCosta, I'm going to interrupt you there. Your comments need to be germane to the...
They will be very germane.
Okay, carry on.
This is what I do for a living.
Okay.
So, we have a case here, just by the introduction of people who come here to represent and throw some light on it, he has made it convoluted. Where is the representative from the Board of Supervisors? That's the first question that should be asked. As has been discussed, we do have a system where Whatever was deliberated has been videotaped. And irrespective of what we think happens from the angles of the camera, I know there's other feedback, raw feedback, that can be brought to the fore. So, this is how we waste time. We waste the people's time. And I'm not disparaging any one of y'all who has chosen to represent San Francisco. We have very astute people in San Francisco. But we have despicable representatives who create this type of confusion. Despicable. What y'all have to do now is to find out if with intent, this nonsense was created to be brought again and again and again, or do we put an end? And I know that y'all come from different disciplines, but you should know that we are watching. My name is Francisco da Costa. I represent the first people, the Muwakma Ohlone, of this land that was stolen. But I'm also an advocate. I'm the director of environmental justice advocacy, and I was 6th Army's last congressional liaison. I know how to deal with this type of issues. Thank you very much.
Thank you very much. Welcome, former member Nee.
Good afternoon, Task Force members. First of all, I want to congratulate each of you on your appointment or reappointment, and second, to thank each of you for what will at times seem like very onerous work. It can be, and believe me, I think you'll also find, though, that it's a labor of love. Regarding what's going on before you right now, there is precedent. And if memory serves me correctly, that precedent occurred at the meeting of September 2011. So I would respectfully suggest that you go back, look at the minutes, and as time and resources permit, listen to the audio tape of that particular meeting. That meeting, the case at hand at that time involved a Land Use and Economic Development Committee and then Board of Supervisors decision the same day on a residential development contract for Park Merced. And right before the Land Use and Economic Development Committee voted on it at the very last minute, Supervisor Chu slipped in 14 pages worth of amendments, and there was a lot of protest about it. The task force did review the matter and determine violation unanimously. Now, the city attorney at that time had said, well, these amendments aren't substantive, so go ahead and vote on it. You're not really changing what appears on the agenda here. The task force, after a lot of work on it, disagreed and voted unanimously. And by the way, the task force at that time did include a voting member attorney who specialized in sunshine law. So there is precedent here, and I think that can help inform what you do.
Thank you. Very valuable.
Good afternoon. I'm Peter Warfield, Executive Director of Library Users Association. I, too, have been here coming to task force meetings for a long time, bringing complaints and bringing other material, and welcome to the new members. Thank you to new and old member Wolf for mentioning the minutes being not in order. They are not in order. Your bylaws say that they should be taken basically first, and a bylaws change, to my knowledge, never happened. It may have been the wish of the task force, as the clerk mentions, but it, to my knowledge, was never voted upon, and I hereby would ask to see the documentation of that decision by the task force. With respect to this matter, I think you're getting a good representation here, but I think there's including the both of the folks who've spoken from the public as well as the presenter. Let me just give as an example, a hypothetical example. My interest is usually the library. Suppose the library comes to a library commission meeting. The administration presents a budget to the commission. Book purchases are being increased by some wonderful amount. I get up and make comment among other people, isn't that grand, and maybe you could beef up such and such a collection or this other collection and so on, or fill in gaps that have, from times that are poorer. I sit down, other members of the public sit down. Now, there's a motion to amend the presented budget. We're going to cut the book budget out completely. I'm not saying this is what they have done or will do or might do. I'm suggesting as a storyline. Have I had a fair opportunity to comment on that item? Is that item even the same when they make a change like that? I don't think so. So under your requirements for agendas, under 67.7, and by the way, this Sunshine Ordinance is missing from the room, is missing a number of sections. But what it says is, what does an agenda have to tell the public? A description, which is required in the agenda, is meaningful. I'm reading from 67.7b for boy. A description is meaningful if it is sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item, that he or she may have reason to attend the meeting or seek more information on the item. So I think it's very dangerous to leave it strictly to the legislative body, who may be as bad as a previous speaker said, or not, or may simply not get it, what the impact is. It's dangerous, and contrary to this item in the ordinance, you should determine whether a description and whether the item was considered in the way that it should have been considered based on its agenda materials, including attachments. And so therefore, I think any change would be wise to be considered for public comment, including if there are a lot of amendments, all of them at once. I've certainly seen where bodies take comment on every amendment, or all of them. Thank you.
Any other members of the public wish to have public comment on this? Quick question for DCA COLA, and again, that precedent that was cited, I guess that was not in our packet as being referenced.
The precedent, well, when I say precedent, that's case law?
I guess this is true. Fair enough. Okay.
That may have been a previous order determination issued by the task force.
Gotcha. Yeah. Gotcha. Okay. I'm just making
predating
sure.
me.
Right. We'd like to see that as law, but of course it's not. It's not. But okay. I'm going to give Mr. Planthold a chance to wrap up, and then the representative from the clerk's office, if you'd like to, and then just last thoughts from us.
I'm not wanting to rebut. I simply want to make a point. You heard statements that in this hearing, apparently the deputy city attorney did not object. And that's different from making a determination that an amendment is not substantive. And I think that's something you folks ought to consider. I was in the room. The deputy city attorney did not whisper, pass a note, or say this is not substantive. And so here again, silence is not assent. If there'd been just a simple, this is not substantive, that could have informed the public, but instead this just sort of went silently by. And that may be the common practice, that only when the deputy city attorney objects does something get done, but that's not assent. That's not a determination automatically known, made to the public. That's all. Thank you.
Yeah, it just makes me think, like, since the Park Merced case, has the practice changed? Does the DCA step up and say, no, this is substantive, we need to hear this again? I'm just wondering. I'm going to guess probably not, but Member Wolf?
I would just say that, it's the question becomes who asks the question, if it's substantial or not. So if it is silent, if nobody says anything, then the question is it really substantive? And because nobody says anything, then it's not substantive? That then it's up to the public to determine whether it's truly substantive or not, and then possibly take legal action if it was. I mean, it seems a little odd in the course of a legal open public hearing, on such items where an amendment is made, that there isn't a determination, at the moment, at the time. A chair should ask, a chair should know, that kind of thing. These aren't, first timers. They're pretty well exercised.
It's definitely a balance between a slippery slope and then being too burdensome. But our job is to err on the side of more transparency.
Right.
So at this point, is there a motion anyone would like to make?
I move to continue.
A second.
And I would add, and just to add on this, is that we would also request an official opinion or determination from the Board of Supervisors whether these amendments were substantial or not.
Yeah, I'd like that letter to be, or memo to be crafted carefully. I'd also like to pull in the 2011 case. Yep. I think that's relevant here. Member Eldon?
Do we know if this issue is coming up since this particular case was heard originally? Do we know if there are amendments happening on the Board of Supervisors that are not going or may not be going through the correct process? Is this a more general issue, or is this
That's my next complaint.
I mean, yeah, through the chair.
Yes.
This is essentially the same case or the same sort of issues. It'll be recurring in most of these complaints that are on the agenda today.
Okay, but I mean beyond beyond Mr. Planthold's concerns, do we know if there are other complaints from other people that have been coming up along these lines? Is this a regular issue between the Board of Supervisors? Okay. Okay.
Mr. Chair?
Yes.
So you had mentioned that there was an issue in 2014. Is that?
I believe it was September 2011, as stated by former member Richard Nee.
So is that the one you were referring to?
That's what I'm referring to,
okay.
yeah.
So that was the Park Merced case.
Park Merced.
So it's very significant. I would definitely urge people to watch that video. I was on the task force at that time, and it was very significant. And we didn't make that decision in haste. That took months and months to make sure that the right decision was made. So we did a lot of due diligence on that particular case to make sure we were right.
Yeah, I'd like to see some analysis as to how close that is to this and other matters.
It's all on the record.
Yep.
Just to restate the motion is to continue the matter to the college chair. There is a request that the respondent provide an official opinion as to whether the amendment was substantive or not. In conjunction with that, I'm assuming that you wish them to send a representative who can speak to that matter to the next meeting regarding this.
Yes, please.
Actually, can you use the word determination instead of opinion?
Determination, official determination.
Right, because that's how the law is written.
Thank you. That's why I restate.
Appreciate it.
And then I will pull a copy of the September 2011 presidents and try to provide you some information regarding that.
Okay. Yeah.
And do you have an idea of when you would like to continue this matter to?
Not at present. I think let's hear the other two cases. Maybe we'll.
Okay, the motion is continued to the college chair with those provisions. On that motion, Member Eldon.
Aye.
Eldon, aye. Josh Wolf.
Aye.
Josh Wolf, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Bruce Wolf.
Aye.
Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Quintana.
Aye.
Quintana, aye. Fisher, absent. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. The matters continue to the college chair.
Just for the record, it's Member Kanata.
Kanata.
I thought we had an 11th member finally, but
It will take me a little time to get used to
no
it.
worries.
Thank you.
You did so well the first
I
round.
apologize. Next on the agenda. Item number 3, file number 16034, complaint filed by Bob Plantold against Supervisor Katie Tang and Supervisor Norman Yee, Board of Supervisors, for allegedly violating Administrative Code, Section 67.15 and California Government Code, Section 54954.3, by failing to provide adequate opportunity for public comment at the March 23, 2016 Budget and Finance Subcommittee meeting. Is there a motion to find jurisdiction on this matter?
So moved.
Is there a second?
Aye.
Is there any public comment regarding jurisdiction on this matter? There being no comment on jurisdiction on that motion, would you like to pass that without objection?
So moved.
The matter passed without objection with members Copra and member Fisher being absent. Mr. Chair, would you like to provide a summary of how the matters on new complaints are handled to the other new members?
Sure. So basically, our first step is to find jurisdiction, which we just did, which was easy because the previous case we'd already found jurisdiction. And then we'll invite the complainant up, and then he'll have 5 minutes. He or she will have 5 minutes to describe the case. We'll then invite anyone from the public in support of the complainant. And then we'll have the respondent that gets 5 minutes, and anyone in support of the respondent. Then we open it up for discussion. We may or may not have a motion, open that up to public comment, and then take a roll call vote or not as needed. Kind of similar to what we just did. All right.
So I want to point out that here, I think it's a simpler issue in that during that hearing, there was discussion about parents' leave, and then after the public comment was closed, then Supervisor Tang, who allowed for a motion to delete or take out the possibility of a private right of action by somebody aggrieved, such that the only recourse for legal action would be through the city attorney. To me, that is obviously substantive. Because, as I point out, the city attorney has limited staff, limited budget, has to make priority decisions about what type of cases to pursue. Whereas with a private right of action, one can go seek benefit from various public interest law firms. I'm on the board of one. We might have been able to help on this, but others can help on these private rights of action. And taking it out is substantive. But beyond that, there's something that hasn't been addressed in this. There is cited within the response that a phrase about public comment and so forth, then it calls for consideration of the item. I think people are assuming consideration means calling of the item, but in fact consideration really means discussion, question, debates, and that's where there was not consideration of the deletion of the private right of action that the public could be aware of and comment on. As I point out in my complaint, there are many provisions to that section. There are many provisions to others. How do you know which to support, which might be on the chopping block for a supervisor on that committee? You don't have evidence quality mind reading apparent. And so you may advocate for this, and against that, and suddenly after public comment is closed, a major part is thrown out, like private right of action. To me, it's substantive, but as well, there was not consideration. There wasn't debate, discussion amongst supervisors in front of the public about the benefits or problems of the private right of action. And that's where there was not consideration, and therefore, again, a problem. Done.
Thank you. Is there anybody here to support, to give comments in support of the complainant? Seeing none. Is the respondent here? Welcome back.
Sorry, Member Highland. Most of what I was going to say pretty much reflects the matter that we just discussed. So, I mean, and since there was no determination on the prior item, then most of what I've had to say on this item much reflects the previous item. So, pretty much the same defense goes along the way. as far as whether or not adequate public comment was had. We still believe that there is, but I can only speak so much from the office of the clerk of the board. So if you want to hear from any of the supervisors' offices, then you might want to take the
Right.
the same
I just wanted to
recourse.
see if you had any additional material, but I think clearly representative from those offices need to be here. Okay, but thank you.
Sure thing, Member.
Is there anybody else here in support of the respondent? Seeing none, this is open for discussion.
I don't think I'm comfortable taking action on this till we hear from the actual offices.
Fair point. Fair point. I just wanted to ask Mr. Planthold, just give us a little more background since you sit on a board of private rights of action, and you gave a little summary, but I'm trying to see, I guess, the weight of something like that. It's not something I'm familiar with, but if you could tell us a little bit more about that from your experience.
A private right of action is an option in various laws, including some ethics matters, or FPPC, Fair Political Practices Commission matters. And so it's been long available as an option. Now, some agencies don't allow for it for whatever reason, but it was in the initial draft. And as I try to point out again, city attorney's got limited staff, limited budget, has to make decisions on what cases to take to court, what challenges to make. An individual who feels aggrieved may be two small potatoes, may fall through the cracks, but may be really aggrieved financially on this issue and seeking not just public interest law firm, but contingency fee lawyers might take up a case just to get themselves publicity as well as some small income. It is a valid and used tool to enforce a law. California Civil Code even has a provision that a private citizen can sue to enforce a law. So it is not inconsistent with state law. It's not inconsistent with widely available practices. It was mentioned as an option. If it had never been in there, some of us might have said, why not? But we wouldn't have been able to object. But that was in there. And then after we were shut out of public comment, closed off, that seems to me inappropriate action taken because it is substantive.
Okay. Was there any discussion of that at all up until that point?
No.
By any of the supervisors?
It was not mentioned beforehand as to, is this a good idea? There wasn't any statements about this is going to be problematic for the city as to whether we, the city, take jurisdiction, and if not, then allow private attorney or public interest law firm X to take it. Silence until suddenly the amendment was deleted.
Okay. All right. Thank you. Member Moss?
Yep. And sorry, I just have a question for you. I noticed that there were several amendments taken on that item. I'm just sort of looking real quickly. Is there a reason why this one you believe was substantial and the other ones were not?
That's one I'm very familiar with from my work previously on the Ethics Commission when I was on it, and as an advocate for better ethics. I'm familiar with private rights of action, both from that and from my board membership on a public interest law firm. To me, it was like, wow, holy cow thing suddenly just being carved out.
So that one you thought was substantial, but you didn't really analyze the other few amendments that happened.
I was, frankly, I got to say, somewhat overwhelmed, agog at this sliding through without anybody on the supervisors or the city attorney standing up to say, wait a minute, this is worth discussing.
Right. And then the issue with comment not being taken, your recollection, that didn't happen after any of the other amendments?
Nope.
Okay. That's all I wanted to know. Thank you.
Good points. Any other discussion? Any thoughts?
I'll say something.
Member Wolf?
Trying not to be too talkative here, but I find it an interesting conundrum on process. A decision maker hearing everything that's going on, and then public comment happens, and then decides, oh, maybe we should change something. It may be valid. But then the question again becomes, you're not just changing, like a phrase to make it more clear, which would not be substantive. You're not changing something where the, moving paragraphs around so that the flow reads better. That's not substantive. But if you're actually going to remove something that changes the nature of how enforcement happens or how implementation happens or how it affects a certain party, does it create a new class of people? Does it now cost more money for some reason or whatever? That kind of stuff, in my mind, is substantive. So in the way the explanation and reading through this particular case, it seemed to me that this particular case, that there was a substantive change. To remove that particular clause now prevents what a right that would normally people would have. So to me, that's very substantive. That's a light switch. You get to do this one day, and then you don't get to do it the next day. That's pretty clear to me.
Yep. Just quick question for our clerk. Isn't Angela Covillo, I'm kind of searching for the term, an ex officio member of this body?
Yes.
It'd be lovely to have her here today. Would it not? So I think that's a question. These are great questions that she could probably field. She could probably tell us, how the Board of Supervisors conducts its meetings and why they do what they do and how she feels perhaps, where to draw these lines. I think that'd be very, very helpful. So my inclination again is to continue this and, have her perhaps shed some light on this. Remember Josh Wolf?
I'm kind of disturbed by the lack of the supervisors themselves coming to this meeting and basically saying that the complainant has already filed a complaint that's currently ongoing, and so we're not going to participate in this new complaint. Like, this is a different complaint than the other one, which it's not like that one was even resolved. Like, there's nothing that absolved members or representatives from those offices from attending this hearing, and I'm hesitant to just continue the matter without finding a violation for their refusal to attend.
I will say there was a little bit of background back and forth on who's going to attend and who's not going to attend. But without going into the details of that, I think now our position is probably more clear as a result of these deliberations to have someone knowledgeable attend, whether it's Ms. Covillo herself or a senior member. Member Wolf?
Yeah, I would just say if you go back to the original complaint filed by Mr. Planthold, he specifies who these allegations are to, and it was to me obvious who the respondents are.
Right.
So,
and my wish is, Ms. Covillo, I'd like to have her here as part of us.
Yeah, in that respect.
And then also to have the supervisor's aides, or better yet, themselves here. It's not uncommon for a supervisor to appear before us. Member Wolf?
I just wasn't speaking to the lack of Ms. Covillo being here, but the representatives from
supervisor's office.
Yes.
Got it. No, I understand that. Yeah. From the supervisors named in the complaints. Do I hear a motion to continue?
I'll make a motion to continue to the call of the chair.
Second.
Is there any public comment regarding this motion or this item in general?
Peter Warfield.
Excuse me.
Peter Warfield, Executive Director of Library Users Association. On this one, as the prior one, we don't have any particular knowledge or we're not a party, and we're not a party to this. But I'm also troubled, as Member Josh Wolf has said, on this as in the prior one. First of all, I can't cite you chapter and verse, but you're supposed to take the public's side when there's a question or when it's not clear. You're supposed to side, or as you might say, err on the side of the public. And I think it's very clear what's happening here. Page 53 of your packet has the statement from Mr. Planthold, which I think is very clear with respect to the significance, with respect to what happened and its significance. What has happened is that anybody who feels they've been wronged by their employer can find a lawyer, versus the only person who can bring an action if I or somebody else as an employee feels wronged is the city attorney. That's a huge difference. Now, I've also made the argument in the previous item that I don't think the agenda has been properly presented, and Member Bruce Wolf has talked about mechanisms for alerting people about changes to the agenda generally, and that's in another section. But I would say you should err on the side of absolute every change, because how does the body know without public comment if perhaps to somebody in the public it's evident that there is a significant impact as a result of what to the supervisors or the other legislative body might seem minor? When Scott Wiener took as his revenge for being found in violation on the Park Merced illegality the destruction of the old task force, the old good one, and made sure that not one person would be reappointed, when there was a change made at the Board of Supervisors to knock member Bruce Wolf, who thank goodness is now back, to knock him out, there was no public comment taken, as I recall, and there was no awareness that he was the only member who had a physical disability, and that as a result, this task force was paralyzed for something like 9 months when it could not meet because it didn't meet the statutory requirement to have a physically disabled person on it. So I think the simple thing is to take all the amendments and give them to public comment, or one by one, and I've seen that happening routinely. Again, I don't think the agenda is fair, especially if there's an advance intention to change what is being provided, and then it still doesn't provide the proper notice. You should find the violation also for lack of somebody being here who knows what the issues are, as is required under your rules. That should certainly be a violation, and you should find a violation of the law. Thank you.
Thank you.
Good afternoon. Good afternoon. I'm still Richard Nee. Referencing what Member Josh Wolf said about wishing somebody from the actual respondents' offices were here, you're up against kind of an error of omission from the Sunshine Ordinance. If this were a public records case, there wouldn't be any doubt. Section 67.21E requires that respondents to public records requests come to the task force meetings to be able to answer questions about the matters. But that doesn't refer to matters involving public meetings, and nothing in the ordinance, again, this is an error of omission, nothing in the ordinance refers to respondents to complaints regarding public meetings. So I think the task force has found in the past, kind of in the spirit of Sunshine, yes, they should be required to be here, but then again, they go before the Ethics Commission. The Ethics Commission looks at it and says, well, but they're not violating anything in the ordinance. Case dismissed. Good luck.
Thank you for that dour forecast. Any other members of the public? Comments on this particular case? We actually didn't do summations. My errors and omission right there. So I'm going to allow Mr. Planthold to summarize real quick or rebut.
Folks,
sorry.
Look, there's a demographics issue that is implicit, but I've got to be very explicit. I'm a single parent from decades ago. My kids and I, we went through Head Start. I'm aware of a lot of other single parents who work and work hard and had to put their kids in daycare. I want you to start looking at this not from your viewpoint, but if you're a single parent and you're trying to take advantage of paid parental leave and you're not getting it because the employer dances around or does something or loses paperwork and you don't have any other recourse except city attorney, do you as a single parent have time to take off from work to go meet with the deputy city attorney, to meet with the investigator, to go through all of that? My point is that this can be burdensome for the individual parent family who is trying to take advantage of the benefits that would be provided by this law. And closing off this option really puts those people out in the cold. They don't have access to court, period. In that, I'm saying put yourself in their viewpoint, the people for whom this should benefit, the people in need, not necessarily people like you. Thank you.
Thank you. Does a member of the Office of the Clerk have any summarizing comments? Okay, thank you.
On the motion to continue the matter to the call of the chair, with the invitation to the clerk of the board to attend the next meeting, and in addition to talk about the determination of the process for determining what a significant change to legislation is.
And let's reissue an invitation to the
Yes.
Supervisor's offices named in the complaint.
Yes. On that motion, Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Pass.
Copra absent. Member Tesfaye.
Aye.
Tesfaye, aye. Member Bruce Wolf.
Aye.
Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Henze.
Aye.
Henze, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Josh Wolf.
Aye.
Wolf, aye. The motion passes. At this time, it is past 5 o'clock. Would you like to take general public comment at this time?
Yes, please. Actually, we did.
Item number 9, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Hi, my name is Ann Trabeau, and I want to recount again a bizarre incident on the part of Howard Lazar of the Arts Commission. I haven't spoken to that man in over 15 years. He's the director of the Street Arts program. On May 16th, about 4 o'clock, I was waiting to take a ferry to Sausalito from behind the ferry building. It's a terminal there. There's a waiting room, and I was there with a ticket waiting. He came out of the men's bathroom and began ranting and raving, almost screaming, that I didn't have a ticket. He's calling the police. He wants me arrested. I jumped the turnstile. I said nothing. I sat in my seat and just taped him from my phone. This rant went on for about 20 minutes. I didn't take the ferry because it was just too bizarre. And then the next morning, I made a document request, and he had sent a 6-paragraph email to Margaret Baumgardner, city attorney, inventing an entire situation that did not take place. There was no guard there. There's no security cameras. I do not have to divulge to another member of the public whether I have a ticket or not. I don't even have to acknowledge that they're even there. He just invented a story about how I jumped the turnstile. There was a guard who told me to leave. I didn't want to leave. They were calling the police, and on and on. They admitted to having no documents, no videotape, no audio tape. He just lied and invented this situation, and it's these types of things have gone on for so long. It's really very scary and annoying. No police report. What was that? I just don't get it.
Any other members of the public have public comment on items not on the agenda?
Yes, Peter Warfield, Executive Director of Library Users Association. We've been coming individually and as Library Users Association for very many years, longer than anybody who has been here before me in any case. We've won most of the cases that we've presented. In some cases, there was a loss of quorum in the middle of the hearing. In other cases, there was a supermajority required, which is an issue that the task force in its previous iteration, in one of its previous iterations, has dealt with. Any time that one of you is absent or any time that a seat is not filled, you present to the public an extra burden to get what's considered to be the requirement for a favorable decision, and that is 6 votes, the majority of the seats, not the filled seats. So when you have 1 or 2 vacancies and 1 or 2 people don't show up, all of a sudden there's only 7 people. And now the public needs a super duper majority of 6-1 to be able to get a favorable adjudication. So first of all, again, welcome to the new members. It sounds very promising already. I would say your most important, one of your most important jobs is to make sure that there are fair and prompt hearings under the law happening here. Fairly straightforward, fair and prompt hearings under the law. I would remind you that the law requires for document cases in any event a 45-day time limit for your decision to be given to the complainant. And that's not been observed. That has not been observed. And in fact, the complaint procedure that's supposedly being revised and has been on the agenda here at least 8 times hasn't mentioned that in the drafts that I've seen at all. That is certainly something I think you should keep in mind. I think it's important also that you keep in mind that the folks that you're working with who are assisting you, the city attorney and the clerk of the board's office, are offices who have a pony in this race, who have been found in violation both, and not just once. In addition, they've given you advice in their role here that this body has rejected in the past, and you're certainly entitled, and in fact, it's your job for you to make the decision, and as much as you may ask for opinions or advice, to keep your independence and read the law and make your own decisions independently. Thank you.
Thank you. Any other members of the public have public comment? Seeing none, public comment is now closed. I'd like to press on with a few more items before potential break. Is everyone okay with that at this point? All right.
Next on the agenda, item number 4, file number 16036, complaint filed by Bob Plantold against the State Legislation Committee for allegedly violating Administrative Code Section 67.7 by failing to post the April 13th, 2016 agenda online 72 hours prior to the meeting and failing to post cancellation notices prior to the meeting.
Motion to find jurisdiction.
Move.
Second.
Move to find jurisdiction.
Okay.
Is there any comment regarding jurisdiction at this time?
Peter Warfield, I and we do the task force a favor generally by not commenting. Generally, we're in favor of jurisdiction and don't take up your time to say that over and over again, just so you know. But appreciate your asking for public comment as is appropriate. Thank you.
Thank you. Mr. Plantold?
Can you find jurisdiction without objection?
Without objection.
Thank you.
Start the time, please.
Yes. One moment.
So I had a specific bill that I was monitoring that was supposed to have been on this agenda, and that's why when I saw that it hadn't been posted, I wanted to say, whoops. this is the time of year when things really have to crack fast with the state legislation. You got to move. And I wondered, are they going to try to, out of expediency, have a meeting even though they didn't post it? That's why I filed a complaint. So I see that they say they posted a cancellation notice, but it wasn't there as of Monday, less than 2 days in advance. That's a question of how quickly I don't know that there's a timeline for posting a cancellation once you get notice of a problem of failure to comply with the 72-hour notice. That may be something future drafting may consider. But so they posted a cancellation notice. I need to go further because there's additional cluster snafus going on with this. So they had the meeting rescheduled to Monday the 16th from Wednesday the 11th. The draft agenda included the legislation I was monitoring. Suddenly, somehow due to the IT people there, whatever, that didn't get on the agenda. I'm raising this because this relates to a similar complaint I filed and figuratively won months ago before some of you folks came on. There's got to be some better timeline work, jurisdiction between when a clerk of a body sends out an agenda to the IT people to be posted, and when the IT people post this. Sometimes it seems like they go home at 5 o'clock each day, and at 5 o'clock on a Friday means if it ain't posted by then, you lose your 72-hour timeline. So in this case, they rescheduled the 11th of May meeting because I complained, rescheduled the 16th. That met 72 hours. Their agenda draft said my legislation item I was concerned about was going to be heard. It got dropped. And the earlier item I mentioned to you folks was referred to the Education Committee for whether there should be some guidance. That item had to be continued because I was part of a deposition in a federal civil rights lawsuit. But this is a similar situation where there's a time gap between when something gets sent out to be posted and when the IT people get home or when they have to clear it for whatever reasons of the wording. And suddenly meetings fail to comply and can and should be canceled, as well as why did this one agenda item get dropped from the draft agenda? I don't know. I acknowledge that they did say, oops, Bob was right. This didn't get noticed in time. And the cancellation, I'm going to suggest also as a consideration, how quickly should an agency file a cancellation notice? I think that's unclear and ought to be stated. But beyond that, with regard to education, add this to the other one on that committee's agenda for getting some better time coordination. Maybe agendas need to be out 4 days in advance to the IT people, so that if somebody's sick, on vacation, out on family leave, at a conference, their alternate can quickly take up the burden and get things posted in time. Because the other complaint I did, that was a situation where somebody was out and there was no alternate ready to take over, and suddenly things sort of stopped. This is a big government. This is a big city with nearly a $10 billion budget. You shouldn't stop because one person's out sick, on vacation, at a conference or whatever. There's got to be better timing, better coordination. That's why some of this may be better referred to the Education Committee. Thank you.
Thank you, Mr. Planthold. Is anyone here in support of Mr. Planthold on this item? Seeing nobody. Is the respondent here?
Hello, my name's Andrew Dayton. Hello, thanks. Thank you for having me. I'm with the Mayor's Office, Deputy Director of Legislative and Government Affairs. And as Mr. Planthold just stated, we in our office, just to give you the timeline, at 9:07 on Tuesday, April 12th, received the email from the task force indicating Mr. Planthold's complaint. We looked into it quickly and realized that, as we state in our response here, the agenda hadn't, in fact, been posted in time. So at 11:34, I believe it was, we sent out an email to the webmaster and to the public library to issue our cancellation notice. And both of those emails are included in your packet here, and we never held the meeting. And so after consulting with the city attorney's office, we were advised that a violation of the notice requirement would have occurred had the meeting on April 13th been held as scheduled. But because it was not, or because it was canceled, there was not a violation of section 6.7 or 67.7. And as we said in the letter, we thank Mr. Planthold for bringing this issue to our attention. Thank you.
Okay, thank you. Anybody in support of the respondent? Seeing none, this matter is open for discussion.
I have a question for this. Sorry, it was
Andrew Dayton.
Andrew Dayton. So did an agenda exist for this meeting that just hadn't been posted online?
Yes, it got posted Monday morning, which, again, it needs to be posted by, the meetings are held Wednesdays at 11 a.m. That's the regularly scheduled meeting, so it would have needed to have been posted by Sunday at 11 a.m., but wasn't posted until Monday morning. So that item was posted, but it was late.
And sorry, can you walk me through what the error was?
Sure, it was frankly my fault. Usually I send these out on Friday, and they get posted by close of business Friday. We had Secretary Castro, the U.S. Housing Secretary, in town for a meeting, and I just ran out of time, so came in on the weekend and sent it in, not thinking that the webmaster wasn't going to be there to post it when I sent it. And so, again, appreciate Mr. Planthold bringing that to my attention. The second item that he raised, that item or that agenda in terms of the special meeting that we then called to replace the canceled meeting, that agenda was sent to the webmaster in advance. It was posted on time, but as Mr. Planthold indicated, the item that he was tracking was accidentally left off by the webmaster. We have an email of apology from them for that, but that one was at least posted on time.
Thank you.
Yep.
Member Eldon?
It seems pretty cut and dried.
Yep.
I have a question.
Yes,
So, was there any discussion from the mayor's office on the cancellation notice for the meeting? Because it seems like the complainant has two separate issues.
Oh, right.
One has to do with agenda notices, and that was dealt with appropriately. The meeting was not held. It was moved to a later date.
Right.
But then he brought up the cancellation notice.
Yeah. Sure, there was, and we discussed this with the city attorney's office. As you'll see in the April 19th response, we included a footnote because our thinking was that there might have been a mistake in the summary that was provided, which does seem to indicate that the complaint was alleging previous cancellation posting violations. We read Mr. Planthold's complaint to indicate that the fact that we had posted previous cancellation violations was indicative of the fact that we were aware of this process and missed it this time. When we saw that item was still in the complaint description in our second response letter, and that's when we included as an attachment screenshots of previous cancellations dating back through 2014, I believe. We could have gone back farther, but figured that was probably enough. So if that is included in the complaint, we would respond and say that the website indicates that we have, in fact, posted cancellation notices for previously canceled meetings.
I have a question for the complainant. What is the relief you're requesting for the cancellation notice of meetings? Because I think I'm missing that portion.
Here, it's that there ought to be some better timeline or way of getting it noticed. I didn't get notice of the cancellation, and I made a complaint against this body, State Legislation Committee. So I would have thought they would have sent something to me at least. I didn't get any such thing. But beyond that, it's also unclear. As with other complaints I've made, I know who to send it to within the department or agency. But in this case, Mr. Dayton introduced himself as deputy director, yet there's a Nicole Elliott who's the director. So I didn't know who to send it to say, hey, that they could have got notice Monday morning rather than Tuesday morning to give them more time. And I want to be clear, there's no animosity. I've got a meeting at 2 o'clock tomorrow with Ms. Elliott, not just about this, but other suggestions I've made to improve this committee. But it's going to help the public to know if you got a complaint against Body X, not only send it to the task force, but send it to Fred at Body X or Ethel at Body Y. Let us know so we can help prevent the public from going to a meeting, because they may just Monday morning seats on the agenda and show up Wednesday without realizing, oops, it's been canceled. And for that reason, knowing who to complain, send a copy of the complaint to, could help everybody, could alert the agency faster and the public faster.
Okay, so it's not that you think that the meeting should have been held.
Oh, God, no.
Okay, because cancellations can happen moments before a meeting.
I understand.
Okay.
I've done it myself with ethics meetings, yes.
Thank you.
Just for the newer members, many times we'll have people come up here, and it's refreshing to hear respondents that are that contrite and direct and obviously have some sort of sunshine or meeting notice posting system in place. And sometimes, just for the record, we need to lodge the fact that there was a violation. And I think normally that would be cut and dry, although I'm struggling with whether a violation took place because the meeting never did. So that's I think, the issue we need to talk about. If we can determine whether that happened, then I think we just lodge it as a violation, put them on notice, and we've done our jobs at this point. So I invite any discussion to that. Member Wolf.
So I'm going to take back from the complainants. He started the conversation, the testimony out with this, that he thinks that this should go to the Education Outreach Training Committee. I think that's a perfect opportunity. This is one of those times where I think this is good. And what I think that they should consider is they can consider bringing somebody, if it's Mr. Dayton or anybody else, or even the webmaster, to come in and hear some discussion about it, but also maybe create a communique to the rest of the city family to say, we have a precedent here, and we want to help you avoid some undue diligence on the public. So here's a reminder, because this is in a direct violation. So I think that it's a good would be a good task for the EOT committee to do and to deliberate on.
Yeah, I agree with you, Member Wolf. I'm not even sure.
But a violation had occurred, nonetheless, whether admitted or not. The violation did happen.
Can you clarify what was the violation again? Because the meeting was not held, so I'm confused about.
Right, but the meeting wasn't held, but the original agenda was not posted in the proper time, and even though there was remedy to it, doesn't mean that there wasn't a violation. Now, whether we want to hold that violation, we want to hold anybody to that violation, is a whole other conversation. But you can't discount that something occurred. And the question is whether it was corrected or not. It was corrected in timely fashion, I agree. And that's why I said it's two different questions. Was a mistake made? Yeah. Was it remedied? Okay. How do you want to then deal with it at that point? That becomes the question for this body. But I think but we do have to recognize that the mistake was made.
So just to make sure I understand what you're saying here, as of 72 hours before this meeting was said to happen, there was no agenda.
No, there was an agenda, but it wasn't posted on the internet.
Right, so there was not a posted agenda. So at that point, the meeting was still happening, but there was no agenda, and that is the violation you're saying.
Correct.
So I tend to agree with that, and part of my thought on this is that this meeting to serve the city should have happened. Like, not in violation, but I mean, it should have been noticed, and then the public's business should have been conducted, and there should have been a hearing. But because of the mistake, not only was there a violation, but no hearing happened, and therefore legislation which needs to be acted quickly on may not have been acted on. So I feel like there was something negative that happened for the city in addition to the violation.
Mr. Chair. So correct. I mean, the better way, I think, to clarify it is what would have happened if the meeting did happen, okay? And now we're here after a meeting did happen. How do you then create a remedy for that? Now, if you went to a court of law, court might say, was there anything really substantive in that meeting that happened? And if there was, he'd say, do-over, okay? So that's really kind of where we get to. Here they were very responsible. They took it in their own hands to do it. But I think you also have to look at what happens when it truly does get violated at that point. So you have some context to it.
I just wanted to add, and I like the fact that there was a subsequent meeting notice that they pulled because there was something they felt was not accurate. So I'm certainly seeing some contrition and remedy and getting it right. And I'll talk more about that for EOTC. I just want to put a quick question to our clerk, Victor, who also posts meeting notices. Is it common practice across the city body, the city family, for you to send your notices to a webmaster who then posts it? Is that standard?
I can't speak on my own behalf. I do post my own notices.
You do?
Yes, however, from my experience and speaking with other commissions, they do use a webmaster.
Okay. All right, that's interesting. Member Wolf.
I have a question for Mr. Dayton. So, if you go to the meeting, if you had gone to the meeting's website at the point the complaint was issued, did it list the meeting as being scheduled without an agenda?
I think what he's trying to...
I don't know. I would have to check the web.
Is it a regularly... Our Wednesday is regularly scheduled?
It's a regularly scheduled meeting. I'm not sure if it lists. It would certainly indicate that regular meetings are the first or second Wednesday of each month. I'm not sure if it already lists in the queue the next scheduled meeting.
Right. I mean, so where I'm coming from is I definitely can understand where Member Wolf is identifying that a violation occurred at the point that the 72-hour notice wasn't held, but I think there also is a legitimate argument that until the meeting's announced, that it isn't actually scheduled. And so even though it's regularly scheduled on such and such a day, by not calling the meeting before the 72 hours and then issuing the cancellation, like because we don't have a definition of when a meeting must be canceled, you could make the argument that it was never called in the first place and therefore not in violation. So I see both sides to how this could be interpreted. And if the website had explicitly said that there was supposed to be a meeting that day, that would sort of undermine this alternative perspective and reinforce what Member Wolf is saying.
Right.
Member Wolf, good point. Just to make sure we have the timeline correct, Mr. Dayton, was the meeting noticed however many days ahead? And then Mr. Plantholt said there's no agenda, and then you retracted. Is that how it happened? In which case, when was the meeting first noticed?
Well, I mean, the meeting's first noticed, at least from my perspective, when the agenda is posted. Again, the website will indicate that the meeting meets the second Wednesday of each month.
Our website's the same. I mean, we have, it states it there, but I think, on our website, nothing appears until the agenda accompanies that date.
That's what I think, but I don't know that for a fact.
All right. Member Wolf?
Just offer a little clarification. So sometimes it's a little confusing as to what is a meeting notice and what is an agenda. The agenda isn't necessarily a meeting notice. So generally when a body creates a schedule, regular schedule, the meeting notices are kind of ad hoc, they're already done, so pro forma. But it's the business of that meeting that must be posted. So it's the agenda. So the question here, I think, is better is when was the agenda published and posted? Never mind whether it was the internet or whether all other means. So you have a number of different places that the agenda must be posted. It must be posted outside the room that it's going to sit in, posted at the clerk's office, posted at the library, posted in a newspaper or whatever, or sent to people. There's a service list and whatnot. They just happen to miss the website. So when was it officially posted? Is the question.
My understanding is that for us to distribute the agenda, it needs to go to go online and go to the public library. And that was sent, as I said, over the weekend because that's when I came in to try to catch up on work.
But that wasn't my question. My
Well, then I
question
don't understand your
when
question.
when you print an agenda and you need to print it for like when it goes on the outside of the meeting room, it needs to be posted at the place of where the meeting is going to happen or at a centrally located place. Like in front of the clerk's office, there's a kiosk that's a bulletin board, and all the agendas for every single meeting are posted there.
Okay, then that meeting was never posted.
Okay.
So I think
this is the education part.
Yeah.
Okay. That, the posting on the internet isn't the only place, and that's where 67.7A is very descriptive as to where things need to be posted. It's a whole separate sentence just for the internet, with a sentence that leads it off specifically where it needs to be posted.
Okay.
Mr. Planthole, do you have any rebutting comments?
I'm suggesting this is better taken up with your Education Outreach and Training Committee for ideas like when a complaint happens, should the agency respond to the complainant if there's a cancellation? Various things ought to be addressed for maybe future amendments to the ordinance. But also there needs to be better coordination between departments or agencies and their IT or webmaster people. Because the previous complaint I had was MTA, and they sent something to their webmaster, and over the weekend their webmaster didn't get it done. So, again, I'm working with the staff tomorrow afternoon with additional suggestions, but whether or not you find a violation, I agree there's at least one violation apparent. But I respect and like the idea of sending it on to your Outreach, Education, and Training Committee, because this represents now an apparent ongoing problem. If it's happening with more than one agency in different parts of city government, this ought to be addressed.
Agreed. Thank you. And Respondent, do you have any closing remarks?
Just to add that there is a website. The State Legislation Committee has a website with my contact information. So if someone does have an issue with the agenda or with anything else with the committee, they can reach out to someone directly in the mayor's office who can respond to those concerns.
Great. Thank you. I think at this time it seems like there's a consensus to send this on to EOTC and invite certainly the respondent. The complainant doesn't need to be there, but the respondent I think would be valuable, and out of that generate a letter to the family family of city agencies restating that 67.7 ultimately is the department head's responsibility. However, that they should look more closely at potential disconnects between their clerks and their webmasters, because the buck's going to stop with them, but they need to make sure that gets tightened up. I think since this is a clear case of that, and then whether we find a violation or not is something we can certainly take a vote on. So, if someone would like to propose that motion, or I can propose that.
I'll move motion. I move to refer this item. First of all, I'd like to find without how should I say this? Without
prejudice.
Without prejudice or malice, I would like to find in violation of 67.7A and 67.7C. Which 67.7C is just one sentence, says the agenda shall specify the time and location of a regular meeting and shall be posted in a location that is freely accessible to the members of the public. And by their own admission, that wasn't done. So, that this item be referred to the Education Outreach and Training Committee with a recommendation to form a communication to the city family regarding the proper posting of agendas their locations, and the cancellation process.
And I'm wondering if we can add to that. It would be nice if there was one or two city webmasters that regularly channel these these notices.
You want to make that part of the motion to request that the webmasters?
Sure.
Okay.
I mean, why
I
not?
don't know if there's a master webmaster.
Each department has their own
They have
webmaster.
their own. Yeah. So, well, actually, communication would include them.
Yeah.
How about that?
Should do. Yeah.
Okay. But I don't want to make too much directive on the committee. Let them figure it out.
Okay. Do we have a second to that motion?
Second.
And if we can take some public comment on that motion.
Peter Warfield, I'm glad that you've had this discussion, and I'm glad that you're making this motion. I'm also glad that the mayor's office has seen fit to send somebody knowledgeable to this meeting. I certainly can say that I support the motion, and I'm glad you're making it. I can also, as a bit of history, say that this task force, I think too often, has taken a different approach, and that is when people are grappling and even struggling with departments to provide information, as an example. It has happened that the struggle finally lands here on your doorstep, and then the department says, oh, we have a pile of material right here. Over and over again, departments have, in the past, taken steps to comply only when a complaint has been filed or after a complaint has been filed, and even at times right at the hearing where the complaint is to be heard. And as regards this body, I think there have been too many times when the body has taken the position, well, since they're being nice and since they're providing the requested material, let's not find a violation. I think that past practice has been very, very damaging to the public and to the cause of open government. And I think in this case, I'm not asking you to send it to the Ethics Commission. That's something that you could do with something really bad. But I do think that you need to take note that the law was broken and thereby alert everybody that you're here to enforce the law and that you will, and that they need to make sure that they need to do what is necessary to follow the law. Thank you.
Thank you. Any other public comment on this motion? Seeing none, public comment.
I have one last. If you're closing public comment.
Yeah, public comment.
I just want to say that usually it's in my years of this, it's the best advice for a complainant is never to bring a complaint against a body, a thing, so to speak, because somebody has to be responsible for it at some point or another. The ordinance is specifically about people, so to speak. Now, in this case, when we're talking about agendas, we are talking about bodies, but it's the people who run those like the chair should know, kind of thing, how this is done, and can ask staff, was this done or wasn't done properly, that kind of thing. So it's really about the responsibility of people's actions and so on and so forth. So, I just want to say this is just really more of a shout out to governing bodies and bodies that meet public, more so than it is directed to any one person.
Yeah, Andrew, next time bring the webmaster in with you on Sunday. That might do the trick. Okay.
On that motion, Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Bruce Wolf.
Aye.
Bruce Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher, absent. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Just in discussion of task force procedures, past practice has been the determination of the chair of the committee to determine referrals. Would you like to continue with that practice, or would you like to agree to accept the requested referral to the OTC? I just would like to make sure we adhere to our procedures.
Sorry, can you restate that?
Usually it's at the discretion of the chair to determine whether or not to refer matters to the committees.
Yeah.
At this point, it was included as part of the motion.
Yeah.
I was wondering if you would like to continue that practice, change the practice?
Yeah, we can continue that practice, and I would agree, please refer this to EOTC.
In accordance with the recommendation from Member Wolf.
And I happen to be chair of that as well, so.
Just a point of information, Mr. Chair. I hear what you're saying. I would just like to say that the priority when the body makes a decision, that takes precedent over whatever the chair's privilege is at that point.
Well,
Interesting.
The point is, it's written into our procedures. That's why I ask. So.
Interesting.
Okay.
Good to know. Okay. As directed by the committee.
Thank you. Would you like to move on or take a break?
How are we feeling?
The next few shouldn't take very long.
Okay. The next few are...
Just a question. Are both parties here for the next?
The next few are recommendations from committees, so the parties may or may not be here at this time.
These were heard previously in the complaints committee, and we're just acting on that recommendation.
Got it.
So they should move fairly quickly. So I think maybe we press on for a few more of these. All right.
Just to provide a summary of the procedure that the task force has at this time.
Did you want to call the item?
I'd like to provide a little summary so they know what we're doing.
Okay.
The committees currently hear complaints and provide a full hearing, and they make a recommendation of what they believe the facts are, whether or not there is a violation or not, and they send that recommendation to the full task force for review. And the task force has the option of either accepting that recommendation from the committee, or if they disagree with that recommendation, they can ask that it be continued for a de novo hearing on a future date, so that we can invite all the parties to return.
So just to reiterate that, so we have a what we call a complaints committee, which is almost like a pre-committee, if you like, of 3 members, and that's in the last couple of years has been added on to 2 other subcommittees. So the first hour of business is, let's say, education outreach, and then the second hour you might hear 1, 2, or 3 new cases and kind of listen, make a recommendation, and forward it on to us as a full committee, and we can either accept the recommendation and dispense with it, or we can disagree with the recommendation, for instance, and reopen it and have it to be a complete new hearing. So that's kind of, and we'll get into the mechanics of that, especially when we get into voting subcommittee assignments next month. Okay. Thank you, Mr. Clerk.
Okay, item number 5, file number 16024, complaint filed by Michael Trellis against District Attorney George Gascon and Office of the District Attorney for allegedly violating Administrative Code Section 67.4A by failing to provide a notice of meeting or an agenda on their website or upon inquiry by a member of the public. On April 19, 2016, the Compliance and Amendments Committee referred the matter to the task force with a recommendation to find jurisdiction and to find that there were no violations of Administrative Code Chapter 67. After discussion, it was the understanding of the committee that the Blue Ribbon Panel is a passive meeting body organized by the Office of the District Attorney. As passive meeting bodies are not subject to the same noticing requirements as policy bodies, there was no violation. Passive meeting body, pursuant to 67.4 of the Sunshine Ordinance, passive meeting bodies do not need to formally notice meetings except on the city website when possible, but must disclose information upon inquiry by a member of the public. I believe Member Eldon was present at that meeting. If you have anything additional to add.
Member Eldon, any thoughts? Just to be clear, I just want to make sure. So the Blue Ribbon Panel was convened by the City Attorney's Office. Okay.
For that case, we all found it pretty troubling that it was all happening with so little transparency, but I don't think we really came down on being sure how to proceed with it, so we punted it to you guys.
When you say bump it up to us, but you weren't requesting a full de novo hearing, or?
That would be the true bunt, but no, you actually found no violation. That's a little different from what I'm reading here.
Okay, yeah, there was a whole slew of Petrellis things that evening, so I may be mixing it up with.
I believe the recommendation was to find no violation.
No violation on this one.
Okay, so
Okay.
that was the one. Sorry, I was thinking of the three other ones that happened.
Okay. Member Wolf.
Yeah, so I find this interesting because when you read the section of the ordinance with regards to passive meeting bodies and with regards to whether it is required to make a posting or not, under 67.4 A1, such gatherings need not be formally noticed except on the city's website whenever possible. That's an interesting way to phrase it. It's almost like it may not be done this way, but it may not be done that way too. But there is an exception to the rule for passive meeting bodies, and then the question becomes, was it possible? And so, I would pose that question, and if maybe Compliance and Amendments Committee wants to review based upon that particular point, or if we want to take an action to overrule it, But I just want to put it out there that it is pretty specific, and then the question, I would have to ask questions of the respondent at that point to notice whether, if it was possible at that time to do it. Like, if it was to be over a weekend and they weren't in the office, okay, then it's not possible, okay? But if it was on a Tuesday and there are 4 more days to the rest of the week.
If I recall from what was happening around that, they're starting to get the committee together, and Mr. Petrellis was trying to find out information about it, and this was part of a range of other complaints he brought against the Blue Ribbon Committee, some of which we found violations for, and this one, that's an interesting interpretation. I don't know. I think whenever possible sounds like it's meant to be subjective, so I think I'm sure it could be revisited and different people would interpret it differently. I'm fine with that, and I don't know what the process is for asking the former members of this task force who are on the subcommittee where we talked about this, but from what I heard from Petrellis and from the context I got from that meeting, it was that he wanted to know what was going on. He found some other things that he didn't like how they did. We found violations, and this was one of the things he threw out there, and I am editorializing here, but my impression is that he came away feeling like he had his say and that he was happy with the other things. However, yeah, you're here. Great.
Yeah. Hi, Nikesh Patel.
Hold on one second, Nikesh. Remember, Testify, you had some comments, or you're good for now? Okay. Please approach. Yeah.
Hi, my name is Nikesh Patel. I'm from the San Francisco DA's office. I'm a part of the policy and communications team, and it's good to see you again. I was here the last time the smaller body had convened. I'm here to answer any questions that you may have, and one that I think may have been posed or in the process of being posed is whether or not a notification was posted on our website about the meeting in question, the Blue Ribbon Panel meeting. It was posted. It was on our website, and we posted the information that we had available. And by that, I mean that there was no agenda information, but that's also because we didn't have any information regarding the agenda. And I bring that up simply because it's a part of the language of 67.4, section 67.4. So I'm more than happy to answer any other questions, but there was a notice of the meeting posted, the time and the location. There was no agenda, but simply because we didn't have that information.
And so the question would be, was it possible for them to have had an agenda by that point that they could have posted? And
sounds like no.
I mean, we don't know that for sure.
Right.
That was our takeaway.
Mr. Chair, I would just further add that with regards to agenda, and it just in this particular line in the ordinance under 67.4, it does state, and any agenda actually prepared for the gathering. So if there wasn't an agenda actually prepared at that time, and again, there's a difference, separate, there's two different objects here. One is the posting of notice of the meeting, the other one is the agenda. So that's why it's very, the Brown Act is very clear on this. So that's where the Sunshine Ordinance comes from. So yeah, I'm fine.
Okay. Mr. Patel, thanks for letting us know that you were here.
Yeah, no problem.
I would have rattled on without knowing that.
And I will be here for the next one as well. So.
I'm aware of that now. Thank you. Any thoughts? So I guess our actions are to accept the recommendation of the Complaints Committee as it's stated here, or we can choose to reject it and find violations, or actually, that's a good point. Can we?
If you reject the recommendations of the committee, we would need to schedule a new hearing on a future date to allow all parties to be present.
Exactly. Yeah.
I think if we proceed down that route, we would want to check with Mr. Petrellis to see if he wants to show up for that.
Right.
Because I'm not, based on the discussion I remember having around that time, he was complaining about how often he had to come here and how much time he had to spend on his different complaints. And I think it'd be worth, if this is the specific one we want to focus on, to make sure we have his buy-in for that as well. Otherwise, he won't show up and it'll get stuck in limbo.
Right. And in the past, he's indicated by email to please carry on, even though he's not here. But I'm wondering if if we can continue this and revisit it based on and hear the other two items.
Through the chair to Member Eldon. Is that okay? Mr. Chair?
Yes, please.
Did you hear this same testimony from the DA's office?
There was basically that whole subcommittee was a variety of complaints brought by Mr. Petrellis against.
Yeah, just on this one point about the posting of the.
Yeah.
That did they testify in the previous
That's what I
hearings?
recall.
Okay.
We'd have to review the minutes, but that's what I recall.
Okay, and I'm just wondering if that was the basis for how you came.
I believe so.
Okay. Thank you.
So just to summarize, it sounds like, from what I'm reading, so the complaint is failing to provide a notice of a meeting or an agenda. And it sounds like the notice of the meeting was provided. The agenda, given the circumstances, was not available.
Right. For passive meeting bodies, the ordinance is very lenient. So, because in his own words, I imagine that we can't put him under oath, but I'll take him at his word, that there was no agenda created at the time because it's a brand new body. At least they had the foresight to post a meeting notice as appropriately on the website. So I don't find any violation here.
Okay, I think I'm in the same place now they restated it.
Is there a motion at this time?
I move to accept the recommendation of the Complaints Committee.
Second.
Thank you. Any public comment? Seeing none, can we take that without objection?
Yes. The motion is passed without objection, with Member Copra and Member Fisher being absent. Next on the agenda. Item number 6, file number 16029, complaint filed by Michael Trellis against District Attorney George Gascon and the Office of the District Attorney for allegedly violating Administrative Code Section 67.21, 67.25 by failing to make documents available in any form requested, which is available to or easily generated by the Department, and failure to respond to immediate disclosure requests in a timely and or complete manner. On April 19, 2016, the Compliance and Amendments Committee referred the matter to the Task Force with a recommendation to find jurisdiction and to find that there was a violation of Administrative Code Section 67.21C and 67.25A and B for failing to assist the requester in identifying the existence, form, and nature of any record or information maintained, and failing to respond to an immediate disclosure request in a timely and or complete manner. The district attorney stated at that meeting that the request did not qualify as an IDR, and the standard deadlines for public records requests were applied. In addition, several requests were combined into one response, as it was determined that many of the requests were overlapping. The committee at that time opined that if a department determines that a public records request doesn't qualify as an immediate disclosure request, the requester must be so informed by the end of the next business day. In addition, the committee stated that the city attorney's good government guide is only an opinion of the city attorney, in which there are certain portions disputed by the Sunshine Ordinance Task Force.
Just for the record, Mr. Petrelis is not here, but Mr. Patel, if you'd like to approach.
I believe there was a new memo or email provided to the task force in your packet after that meeting.
Okay.
I believe it's towards the front of the packet.
All right. What page is that? Thank you.
Would you like to allow the...
Yes, if you could give us your background on this.
Sure. And again, Nikesh Patel for the DA's office. I'd like to talk about the complaint for our failure to respond to the immediate disclosure request first. A lot of what I'm going to say is in the memo that we provided, but as a synthesis, I'll provide it here, and then again, I'm more than happy to answer any questions you may have. First and foremost, our office would like to acknowledge that we understand the Compliance and Amendment Committee's position as discussed last time, that the good government guide upon which we relied in our dealing with Mr. Petrelis' immediate disclosure request is not necessarily the say-all, be-all. We understand the position, and that is to respond the close of the following business day. I want to provide a little bit of context of what happened here, though. With the immediate disclosure request that Mr. Petrelis sent us on February 18th, February 18th, 2016, we looked at the Good Government Guide and used it as our language to interpret how best to respond to the request. The Good Government Guide, and I have a copy of this language if you'd like to see it, but it essentially says that a designation of an immediate disclosure request doesn't necessarily make it so. An immediate disclosure request is supposed to be for simple, routine, or otherwise answerable requests, and if the request is more extensive, the department can rely on time deadlines governing standard requests, 10 days for the initial response, and then an invocation of an extension of 14 days if necessary. Based on that interpretation, that's what our office did to respond to Mr. Petrelis' request. His request was on 2/18/2016. Our response was on 2/29/2016. Given the counting of the calendar days, that was 10 days following the request. And again, I have copies of those materials if you'd like to see them. That being said, and it's mainly in the way of context, we understand and respect the Compliance and Amendment Committee's position that the Good Government Guide does not control on this issue. We are working, and we've already started implementing ways to reconcile our understanding with the committee's understanding and are moving forward in that fashion. I would just like to reiterate, though, that our actions with response to Mr. Petrelis' request were not in any way to avoid responding in full or being sincere in our response. It was our interpretation that we could rely on the Good Government Guide, which is created by the City Attorney's Office. We thought that it was going to be a trusted resource. We understand that it's not the end-all, be-all, and we understand a better way to move forward based on the Compliance and Amendment Committee's position. So thank you.
Well, that's a very nice summary. Thank you. Anybody here in support of either the respondent or the complainant? Seeing none in the room, this is open for discussion.
I have a question. Is there a copy of Mr. Petrelis' original request to the district attorney?
I have a copy if you'd like it.
Okay, it's not in our packet, I don't think. I mean, read through almost 200 pages, but I don't see it.
And I believe our office sent those materials after the last hearing, but like I said, I'm more than happy to provide it now. If
I don't want to retry the case if, it's already been sent to committee and committee has found, that there was obviously they're found in violation of it. They probably have already looked into that, and it's prior to my coming here, so I have to kind of trust the process too.
Are there any motions?
Motion to accept the recommendation of the complaint committee.
I'm not sure I'm quite ready for that yet, but if someone would like to second it, we can continue discussions.
I'll second it.
Okay. Yeah, it's hard to know from the without seeing the original request how voluminous it was, but perhaps Member Eldon who was there.
He had a voluminous request, and the issue hinged on they interpreted the city attorney's guidelines for this, which differ in some respects than the ones we follow. And so it just, if they're going to follow, in terms of telling someone the specifics, I believe, where you were trying to provide him with the records based on the city attorney's guidelines, the guidelines we have, and that we are holding you accountable for, required a somewhat different explanation of what your timeline was going to be in communication, and that resulted in the violations. And so what you were saying and have been saying is that you're trying to reconcile the city attorney's guidelines that you were using with ours. And so more specifically, they didn't respond explaining exactly how they were going to try to get them the records within the time frame that we're looking for.
Right. And that was my next question. I think I heard you say, Mr. Patel, that since that last meeting you have provided some or all of the materials requested by Mr. Petrellis. Did I hear that correctly?
I'm not sure that I said that, but every record to the extent that we could, the records that Mr. Petrellis requested were provided to Mr. Petrellis. And this was I'll speak to this in the next issue, but there were a series of requests that were processed by our office from the 18th to the 26th, 4 to be exact. They were overlapping in nature. Mm-hmm. We responded to all 4 requests for the timeline for the request on the 18th. So Mr. Petrellis was in receipt of all the records that we had responsive to those 4 requests. In fact, I hand-delivered the over 15,000 records that we were able to produce.
Okay. Yeah, typically when we have very large requests like this, it's kicked out of IDR. We try to encourage the respondent and the complainant to set up a schedule of delivery, what documents in what order, by when. It sounds like a good faith effort has been made from what I'm hearing. So I think that will certainly determine where this will go, whether we find a violation or not. There is a motion on the table. But, it certainly sounds like, I think, you guys acted in good faith and used, the good government guide as a guide, but perhaps more could have been done. And as we said before in previous cases, I think the feeling of the body is probably to find these violations for the record, just to have them down, and maybe even push this to, depending on whether all the documents been provided to compliance and or EOTC. You do have some time to rebut, so if you'd like to take the time to do that now, and then we'll probably have public comment on that motion that's before us.
Sure, and just so my rebuttal is directed to some of the concerns you may have or questions, from what I'm hearing, it seems like there's some question about what records were ultimately provided and to what extent that they satisfied the requests. and I can document what we were able to provide. There were over 15,000 records. There was an attempt to transmit these records electronically, but there were significant challenges, which I'll talk about a little bit later. So we printed out all those records and provided them, or packaged them in a box for Mr. Petrellis to initially pick up. There was also a CD as well as a USB drive for additional records. Mr. Petrellis had preferred that we send them electronically. Then he asked us to mail them. So we were in communication with Mr. Petrellis and asked if it would be all right if we delivered them. He gave us an address, not his, but of an associate's. I went and delivered them, and I wish I had taken a picture because it was a very large box. In fact, the person that I delivered them to, he was a chiropractor, and he jokingly offered if I wanted a schedule a visit because the box seems so heavy. But all this is a way of saying that we tried to produce as many records as we could that were responsive. There were a lot of overlapping requests, and the problem was that one of the requests was asking for material that another request necessarily implicated. So let's say it was financial information from one body, but the other body for separate financial information was also on the same thread of email. So we tried to also minimize how many records we were producing in an effort to not duplicate records either. All in all, it was a very large records response, and we were able to provide those items. We also went through each record to determine whether or not we had to withhold privilege information given our position as an investigative and law enforcement agency.
Great, thank you. Member Tesfaye?
Can you go into any details on why certain documents couldn't be produced electronically?
Sure.
Or transmitted electronically?
Absolutely. This is something that I was going to talk about later, but it might just save us a little bit of time right now. We initially attempted to transmit the records electronically, but there were 3 levels of difficulty that we faced. The first is when you're dealing with 15,000 records, you have to separate them into different batches if you're going to scan them in. And what that does is it creates many, many, many batches. So the first issue we had was ensuring that each of the batches was actually being scanned. And then this is the second problem. There was a delay in the scan and it being uploaded to our server. So if you scanned too quickly, then it was really difficult to track which batches had actually been scanned because it's not as if you scan, it goes straight into your email and then you can load it onto your network. It scans, it takes 15 to 30 minutes before it uploads. And if you're not careful and you start scanning all consecutively, then they're going to bump into each other. And it's very difficult to determine which of the batches have actually been transmitted, which are in our position, and then which we were able to convey to Mr. Petrellis. So that was a serious challenge that we faced. And when you have 15,000 records, even if you want to take the necessary time to account for each one, because there's so many batches, even if you divide them into 500 pages per batch, it's just a very long and time-consuming process.
Does the district attorney's office have a discovery center, or just because I know that this is possible to be done electronically, so because I have done it for litigation, but what are the district attorney office discovery resources, or only because my concern, the reason for my question, I'll just be upfront about it, is that members of the public will ask for documents electronically because it's easier for them to look through. Right. And so when I see that someone is receiving the documents only in hard copy in this day and age, it appears that it's a data dump, a discovery dump that makes it very difficult for them to find the information that they need quickly. I know that discovery software and staff, people have them for these purposes. And I do appreciate that you did give him the information, and I don't know the details of what kind of information it was in hard copy, but I'm just concerned that if other members of the public are trying to find specific information, they request electronically and they only receive it hard copy, it's very difficult for them to efficiently look through those documents. So if you could just give me any kind of context on what your resources are and your practice in this area for other documents.
Sure. So as far as I know, our resources are me. I am using our copy and scanner to manually feed the documents.
You're physically doing it yourself?
That's right. And that's why I was really familiar with the problems. We did not want to transmit an incomplete set of information. If we had gone through the trouble of providing that many records, we wanted to ensure that Mr. Petrellis received them. Now, I'll say that after our last meeting, we have made a number of efforts to, continue to become more efficient in our process. So there is an effort now to scan electronically. It just requires a lot of timing. It requires a lot of planning in advance. And given the nature of Mr. Petrellis' request, which was like one request after the other, that wasn't something that we had the luxury of doing.
Right. I'd just like to say for the other members, I don't think it is the correct use of Mr. Patel's time to be scanning these documents. If he's an attorney doing this work, that just doesn't make sense financially for someone like him to be doing this. But at the same time, it doesn't look good when you're dumping a lot of documents like that in hard copy on people who are requesting them. It really gives the appearance that we're not trying to assist them in finding the information that they need. But at the same time, I don't think that someone in Mr. Patel's capacity should be scanning documents.
Thank you. Member Kannada?
Yes, just for clarification, both Mr. Eldon and Mr. Patel, in the document here it says that the committee discussed the fact that when the department decided that this was not an immediate disclosure request, they were supposed to get back to Mr. Petrellis by the end of the next business day. Did that happen or not?
It did not happen. And part of the reason it didn't happen is we were relying on the Good Government Guide. And from our reading of the Good Government Guide, it appeared to us that just because a requester designates an IDR as an IDR, if it's extensive in nature, then the regular timelines apply. We understand that that was an incorrect interpretation, but that was the basis of why we did not respond the close of the following business day.
Member Eldon?
And this is a larger point of contention between this task force and the city attorney that I think has come up in other cases and will continue to come up.
Thank you.
Mr. Chair.
Member Wolf?
Bruce Wolf. Yep. We're going to have to find a way to differentiate.
It's easy. I just say Member Wolf. Both of you can talk.
Okay. So I just want to remind everybody what the recommendation, the scope and the focus of the recommendation is coming from the committee. I know the respondent had spoken about a lot of different things about the hardship and about the incorrect interpretation and whatnot. But I'd just like to iterate that the recommendation from the committee, which was unanimous of those that were present, was to find a violation for failing to assist the requester in identifying the existence, form, and nature of any records or information maintained, and failure to respond to an IDR in a timely and or complete manner. That's what's before us today. So, just want to keep, for those of us that are new or returning, because things have changed since I've not been here, but just want to make sure that we keep our focus on that and not, embellish it or add any other parts that are not applicable.
Right, and the sections of code, specifically 21C, 25A, and B.
Correct.
I'd like to make a motion to accept the recommendation of the Complaints Committee.
Actually, we already have one, and it's already been seconded.
Oh, yeah.
But thank you for getting us back to that point. I think we're at that point now. Any public comment on that motion? And Mr. Clerk, if you could restate the motion, since it's been a while since we heard it.
The motion is to accept the recommendation of the committee to find that there was a violation of Sunshine Ordinance Section 67.21C and 67.25A and B for failing to assist the requester in identifying the existence, form, and nature of any records or information maintained, and failing to respond to an immediate disclosure request in a timely and or complete manner. Is there any public comment at this time?
Peter Warfield, speaking as an individual who is not connected to this case and isn't particularly familiar with it, but the issues that are raised here are very, very significant. First of all, the Good Government Guide has been found by many people to be a very poor interpretation of the Sunshine Ordinance, and it's your job to follow and enforce, if you like, the Sunshine Ordinance, not the City Attorney's Good Government Guide, which, let's just say kindly, is highly flawed. I'm surprised to hear the introduction of the clerk reading something that I'm not sure I am seeing in this file, in the explanatory documents. The only thing I could find was on page 119 under the Compliance and Amendments Committee recommendation, where it says the committee opined that if a department determines that a public records request doesn't qualify as an immediate disclosure request, the requester must be informed by the end of the next business day. Now that gets my blood pressure going very high. As far as I'm concerned, Section 6725, which isn't even one page long, is something that everybody can read and I think understand. Basically, it's an immediate disclosure request if the requester puts immediate disclosure request properly on the item. That's it. There are provisions in this section that allow the department who has been asked for information to give information past the next business day. And that's okay if the requirements have been met. Very voluminous requirements to consult another department and so on. But that doesn't make the immediate disclosure request non-existent or not an immediate disclosure request. Section 6725A says, notwithstanding the 10-day period for response to a request permitted in Government Code Section 6256 and this article, a written request for information described in any category of non-exempt public information shall be satisfied no later than the close of business on the day following the day of the request. This deadline shall apply only if the words immediate disclosure request are placed across the top of the request, and so on. And then it goes into the occasional ways in which all of the response doesn't have to be given in the time frame of the next business day, but a response of some kind is required, period. And it doesn't say that an immediate disclosure request doesn't exist simply because it was more or very much more than a simple request. So I'm very much troubled. Where is this opinion from the committee? And what standing does it have? You haven't decided that, I don't think. And if you did, I'd certainly like to see when and where and have it documented. Thank you.
Any other public comment on this motion? Seeing none, public comment is closed.
Call the question.
Member Wolf?
Call the question.
On that motion, Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Bruce Wolf.
Aye.
Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher, absent. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. The motion passes.
And I'm wondering, as
Sorry,
far as...
before we move off this item, can I just ask a question?
Sure, yep.
So this is only because it's fresh in my mind because I just filled out all the paperwork for this commission. But in our code of conduct, there is something addressing individuals who verbally abuse people. And I'm not suggesting anything for Mr. Petrellis. However,
although you could be.
I'm just trying to figure out what our duty is when the communication clearly shows that a member of the staff seems to be very upset by things that have been said to him. And I just want to know what is our responsibility having signed this code of conduct in this situation.
Yeah, it's a good question. Perhaps one of the older members, and I mean that in terms of experience only, would like to field that one.
Well,
before we answer that, I just wanted to, before I forget, my feeling on this was to not refer this. I think Mr. Patel has demonstrated, obviously a good awareness of sunshine requirements and communications. I don't think this needs to go to another committee. So without objection, I was going to propose that, and then maybe we can field your question. No problems? Okay. Member Wolf?
I would just ask in essence of time and process that we have an agenda item where we can discuss such things.
Okay,
I would like to, maybe if we could defer it to that time so we can continue with the rest of the agenda.
Yeah, so what we do is we kind of have a wish list, put it down, and then we'll kind of address it there. But that's a good
Just
point.
wanted to make sure I was following the code of conduct.
Yeah.
That's it. So.
Very good.
Next on the agenda, item number 7, file number.
Hold on one second. Actually, take a look.
We have 2 more recommendations.
2 more recommendations, yeah. Should we go through with the recommendations? They should be fairly quick.
Okay.
All right.
Item number 7, file number 15164, complaint filed by Andrew Loy against Howard Lazar and the Arts Commission for allegedly violating Administrative Code, Section 67.25, for failure to respond to a public records request in a timely and or complete manner. On April 26, 2016, the complaint committee referred the matter to the task force with the recommendation to find jurisdiction and to find that there was a violation of Administrative Code Section 67.25A for failing to respond to immediate disclosure in a timely manner. To provide a summary, Ms. Trudeau's request was not seen by the Arts Commission as the email ended up in Mr. Lazar's junk email box. The Arts Commission had previously taken steps to ensure that Ms. Trudeau's emails are accepted, but as she had changed her email address, the new email address was not listed on their to accept list. It seems to be a common knowledge that there are problems with emails coming from AOL. Even though staff should ensure that emails are not lost in junk boxes.
Okay, thank you. So again, this is something that's been heard in committee, and we're going to vote on whether to accept the recommendation or not. Mr. Eldon, do you have any further thoughts?
This one seemed pretty cut and dried. It's you can't say stuff got lost in the mail when it's a sunshine request.
Yeah, and I think ultimately, even though it wasn't sent to the custodian of records, the buck stops at the department head, which I believe is Mr. Lazar.
Yeah.
So.
He's not the department head.
No, he's not.
He was the person the email was addressed to.
Okay. All right.
I'll move to accept the recommendation of the complaint committee.
I'll second that.
I believe that Ms. Trudeau is here, and she provided an additional statement regarding this. If you would like to hear
Yes,
from her.
if you'd like to approach Ms. Trudeau.
Once again, no steps have been taken at all to change the way they do things, because I sent an email to Mr. Lazar yesterday, no, actually 2 days ago, which was not responded to. So nothing really has changed as far as them reforming what they do. I just want to direct your attention to page 178, which is the screenshot of his trash box. And what it says is that after 22 days, his messages automatically delete. And it says this item will expire in 22 days. To keep this item longer, apply to a different retention policy. Well, the record retention policy is 5 years, as we know, and I believe this has a lot to do with why their record keeping is so bad. Then there was also the email. There was a different letter that was sent that isn't included in the packet, where Kay Patterson says that Howard Lazar didn't know how to take it out of the trash, and Ann took it out. I would assume that Ann is an employee of the Arts Commission, which implies that Mr. Lazar doesn't know really how email works, which is quite sad. So this is, of course, not the first time he's been violated. They're not here. They haven't responded with any kind of additional information. I sent kind of a timeline of things that I did to ensure that they received something, which is I even called to leave a message after I sent that IDR, which nobody ever picks up the phone there, and I'm extremely cautious about calling since they slammed down the phone for no reason whatsoever. But on page 167, it's the committee made suggestions on how to improve the way they do things. Regular checks of email boxes, that doesn't happen. What was suggested to me is if you're going to send an information request, send it to several different emails of employees over there. Well, that becomes very confusing because on any given day, one isn't there. So it kicks back and it says, well, go to this one. And it just becomes, this is not a viable way to do things, because after everything I've been through, why should I send follow-ups to make sure they received it? The burden is on them to receive it and notify me that they got it if they're going to extend time or whatever they're going to do. So I'm done.
Thank you. Public comment on the motion to accept? Seeing none, public comment is closed.
On that motion, Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Bruce Wolf.
Aye.
Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher, absent. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. The motion passes. Next on the agenda is item number 8. File number 16033, complaint filed by Andrew Bowe against Sharon Page Ritchie and the Arts Commission for allegedly violating Administrative Code Section 67.16 by failing to make draft minutes available for inspection no later than 10 working days after the meeting, Arts Commission March 7, 2016 meeting. On April 26, 2016, the complaint committee referred the matter to the task force with a recommendation to find jurisdiction and to find that there were no violations of Administrative Code Chapter 67. The committee determined that the draft minutes were posted online on the 10th business day in a timely manner, as required. Revised minutes were posted at a later time, but did not violate the requirements of 67.16.
Is there any additional information on this that you were informed of, Mr. Clerk?
I believe that was on the previous item. There was a letter, but
Okay.
I don't believe there's anything new on this item.
All right. Motion to accept the committee's recommendation.
Second.
I moved it.
Ms. Trudeau, would you like to make any statements regarding this item?
Yeah, I just wanted to pull up some full commission meetings so you could see that maybe this isn't a specific violation. I did send an email asking to inspect the minutes, which I didn't get a response to. So here's some full commission minutes. Usually they post very late on the 10th day, and this one posted, I think it's 7:30 at night. The one before it posted later than that, and then these minutes get revised for some reason, so they go down for 4 or 5 days at a time. This one posted at 4:45. So the minutes disappear for days at a time. That's pretty common with them, but that's not the subject of this complaint today.
Well, I think we need to keep on topic here, so thank you for that.
Yeah, but, I wasted your time because this wasn't really a valid complaint. Here,
Thank you, Ms. Trudeau.
you see they were posted, revised, and
Ms.
approved.
Trudeau,
That
we're
means
moving
they
on.
went down.
Victor, just cut it.
Is there any public comment on this matter? There is no public comment on this matter.
Member Wolf.
So, so that was kind of my question was, I'm glad to see that there are notations of the activity of when things are posted here. It's very nice. I like that. So then my question was there any proof that was brought to the committee that this was posted in a timely manner? And did you determine that? Or were you just taking it on the testimony of the...
I wasn't on this one. This is, I believe, the other Wolf.
Oh.
Through the chair?
Yeah, Member Wolf.
Okay.
The other Member Wolf.
As best I recall, they were able to show when it was posted, but I don't believe this three-tiered level of explaining when it was posted was visible at the time when we were looking at it. I think we just had one record of posted, and then they were able to speak to it being revised, is my recollection. It has been a while, but basically there didn't seem to be any clear indication that something had been posted. It was definitely clear that it had been revised later, but there's nothing to prohibit draft minutes from being posted and then being revised at a later date that doesn't fit within that 10-day window.
So again, I'm sorry, through the chair, to Member Wolf, was the agenda, did you find that the agenda was posted properly?
The agenda or the minutes?
I'm sorry, the minutes. I'm sorry, my mistake.
There was some limited form of minutes that was posted within the 10-day window. Those minutes may or may not have been... I remember Pill not being happy with the quality of those minutes at that period, but they were updated to be more in-depth at a later point that was after that 10-day window. So something was posted within the 10-day window for minutes, and then there was a revised version posted later.
Okay, so just to make that clear, the ordinance specifies draft minutes to be posted 10 days after the meeting. They don't have to be in its final version.
Right.
Okay, just to be clear. So that's why you found no violation.
Exactly.
Okay, thank you.
Through the chair.
Yes.
You know,
DCA Color.
In my advice memo, when this complaint was first filed, I summarized what Kate Patterson Murphy stated, that Arts Commission's Director of Communications, and she stated in an email that, and she attached as exhibits to her complaint documents, that she provided these documents and a link to the full agenda to the complainant within 10 days. So, I mean, you could take that for what it's worth.
Okay, thank you. Mr. Clerk?
On the motion? On that motion, Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Bruce Wolf.
Aye.
Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Absent. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. The motion passes. Would you like to take a break at this time?
Yes. Why don't we come back is 7 o'clock enough? 13 minutes, or should we go 7:05? What do you guys feel? 7:05, yes.
Live.
I'd like to call back in session the June 1st meeting of the SOTF. Mr. Clerk, if you could read the next item.
Next item is item number 10, file number 16030, complaint filed by Geoff Lewis against the San Francisco Police Department for allegedly violating Administrative Code Section 67.21 by failing to respond to requests for public records in a timely and/or complete manner.
Do we have jurisdiction?
So moved.
Is there a second to find jurisdiction?
Second.
Public comment on jurisdiction?
If I could just ask what the page numbers are that this is in the packet on, I'd appreciate it. Thank you.
254?
254?
Yes.
Thank you.
Any other public comment on jurisdiction? Seeing none, Public comments closed.
Would you like to find jurisdiction without objection?
So moved.
That motion is approved with members Copra and Fisher being absent.
Okay. Is Mr. Lewis here? Please approach. So you have, how are you? So you have 5 minutes to talk about the case. And if there's a respondent, they'll talk, then we'll ask you questions. Then you have 3 minutes at the end to rebut and kind of summarize. That's kind of the process. You've probably seen it going on a little bit here tonight, and thank you for your patience so far. So go ahead.
So where is the respondent?
May or may not be here. We'll get to that. Is the respondent here? Anybody from the police department? Yes, they're here.
You're
Okay.
from the police department?
Yes. Okay. All right. Go ahead, Mr. Lewis.
What's your name?
We'll get to that later, Mr. Lewis. So go ahead.
So yes, I requested, well, I have a specific complaint and a general complaint, and I'll address the general complaint first. I don't know if you have jurisdiction of the general complaint, but it, in spirit, involves your agency. I was involved in a police incident, and the police didn't give me any information. They didn't give me any report numbers or incident report numbers or CAD numbers or any numbers whatsoever. And I had to go back and call and try and get the incident report numbers and the CAD numbers. And during this incident, my license was taken from me and never returned. So I had to wait until I got my license back before I could even access those documents. Now, my specific complaint is regarding the delays that I encountered and the unresponsiveness by the police department to my requests. I requested that I get an incident report, and I was told that it was being reviewed by somebody in special victims units, and I was given the officer's name and phone number, and I was told it would take at least 2 weeks, and I contacted the officer more than 2 weeks later by voicemail several times, and the officer did not even bother to respond to my phone calls. And then I made a complaint, and the people I complained to gave me these various excuses. And I finally got my documents after a month. A month after I was involved in a police incident where nobody told me anything about any documents with numbers on them. That's what my complaint is about.
Okay. You have more time, so if there's anything else you'd like to go into, you can, or we'll ask you questions. You can elaborate more at a future time, but thank you for that. Is anybody in the room in support of Mr. Lewis in this item?
I don't understand.
Oh, I'm asking if there's anyone else here that's going to present evidence in support of you.
No.
Okay. We just have to go through the procedures.
Okay.
All right, if you can take a seat.
Oh, thanks.
Would the complainant please, respondent please approach?
Hello, Lieutenant Catherine Wallen for Police Legal.
I'm sorry, could you speak into the mic, please? Thanks.
Lieutenant Catherine Wallen for Police Legal.
Hello again. How are you?
Hello.
Catherine
Wallen. 1361.
Yeah. Mr. Lewis, if you could take a seat back in the, thank you. Okay, yeah, we're going to have...
And you make sure you speak directly into the mic. Thank you.
All right. Carry on.
So I think we sent a response regarding this. We originally received a request on March 3rd, and it was an incident that needed to be redacted or cleared because of the information it contained. So it might have been sent to Northern Station first, and then to Special Victims Unit, and then was released to the requester on March 18th. And he had requested all the reports for a certain date, and when I
I'm sorry, please speak into the mic if you can.
He had requested all the reports for a certain date. And so the way they were in the computer, and I'm not sure because I'm the one I don't work in the record room. I don't know how they look for reports down there. But it may have been missed because the original incident started like on the 18th, and I think he requested something on the 19th or the 20th. So just the way it was listed may have caused it to be missed. And when he requested that report, it was given to him. I know we said it in our response. This is kind of complicated because it's a record room issue, not a police legal issue. But I realize that you guys meant to notice Officer Candy Hilder, and you might have sent the notice to Catherine Holder. I thought you guys were trying to reach me, Catherine Walland. So that could be part of the problem. But I know we turned in documents regarding a response to the second request. I know it was in less than 10 days. So.
Okay. Anything else to add?
No.
Okay. Is anybody in support of the respondent here? Seeing none, this is open for discussion amongst task force members.
Yeah, actually.
Member Eldon?
Is she actually the right person to be representing the police department on this?
Yeah, what is your title, Ms. Waller?
Lieutenant for Police Legal. We do handle the public records requests.
Who is your custodian of records?
What do you mean?
Who handles your information requests or sunshine requests? I imagine you get a lot of requests, but is there an official custodian of records? Not that you're aware of.
I mean, police legal, I believe we are. If we get services, the subpoena, it goes to police legal, and then the requests go out to the different divisions that actually contain the information. Police reports are released from the record room. I mean, they're considered not our normal public records requests that would be data or documents that are being released other than police reports. So it's a slightly different protocol.
And so you are the correct person to be representing the police department on this matter?
It's my understanding it's my job to attend these meetings, so.
Okay.
I don't know if anybody else has ever come.
Okay.
Other than from police legal, so.
Member Canada?
Yeah, I'd just like some clarification on the second request, because on March the 3rd, officer, is it Z?
No, he's a civilian employee in the record room.
Okay, he sent out an information to the complainant, giving him CAD numbers and saying the incident report is in transition to special victims. And was there a request for different information besides the CAD reports and the incident report?
I believe the original request was for all reports related to a certain date. And so when the requester received the report, he noticed that there was another report contained within the narrative of that report, and then he requested that report. But if you look into our crime data warehouse, the date of incident, because the incident spanned 2 days, actually started on a different date, and that's why it might have been missed didn't get swept up in that date.
Any other members? Member Wolf?
Yes, a question for the complainant, please.
Mr. Lewis, if you could approach.
So you are stating that you had made a request of the police department for specific records on March 2nd. You made that request on March 3rd, correct?
That sounds correct.
I'm just reading from the record here. I'm just trying to get confirmation so we can get some clarity on what's happening here.
So I'm seeing something dated March 1st as well.
Okay. What page is that?
I see 271. I see 3 different.
I thought it was March 1st.
Different dates.
Okay, because I'm reading from the memorandum. It says March 2nd. but okay, or March 3rd. Okay, so assuming March 1st you made your request for, I'm sorry, March 1st?
Well,
the incident was March 2nd, right?
Well,
was the incident? When was the
Ms.
incident?
Wallen just told me that there are apparently records from February 18th that I have not even been told about until today. So I don't even know what days she's talking about.
All right, hold on a second. I just need to get clarification on our records here.
If I may,
Okay.
I drafted this memo and submitted it to Victor, and then afterwards there were additional documents that were submitted by both parties. Or maybe just on behalf of police. But from the limited records that were submitted on both parties, I did the best I could to piece together the information I had and make the memo.
Okay, I think we need to get a timeline here of the incident that, or the date. I shouldn't say it that way. I'm presupposing. We need to get the actual date of the complaint, of the request to the police department. We want to know what exactly that request is. Sounds like it was for a particular date and time. We need to find out if, from the complainant, if he received that information in a timely manner. That seems to be his. That's your complaint, right, sir? That you didn't
Yes, it is,
receive
and also that I got some excuses that were never explained to me.
Yeah, but we don't adjudicate on excuses. It's we want to know if the law was actually violated. So,
Mr. Lewis, what we're trying to do is establish a timeline, and then based on that timeline, it falls within our purview to then find violations or not. So help us with that as a first step. I know this is you're emotionally invested in this, and
It was March 2nd.
So March 2nd is what?
When I first made my request for an incident report, the number for which I was unaware.
March 2nd.
And the incident itself was on what day?
Well, apparently it was also on, I believe it was on February 19th, February 20th, and February 21st. And
Sorry, repeat that again, please.
February 19th,
yes.
Friday, Saturday, February 20th.
And the 21st?
And there was also another incident on the 21st, but I didn't ask for that incident report on March 2nd. And apparently now there is another incident on February 18th that is related to this that I'm learning about for the first time tonight.
But what we want to...
I understand.
We want to find out what you specifically asked for, and if you did get the information you requested in the timely manner. That's what we have to... That's all that's before us today. That's the complaint you brought us.
I got the March 2nd request in a timely manner, and then I found out about the second incident report, and then I asked for any and all incident reports and any and all CAD reports, and that's when I started having people stonewall.
Okay.
So you got the March 2nd request in a timely manner?
Yes.
And then when did you make your follow-up request?
As soon as I got the incident report that I had requested on March the 2nd.
So I'm guessing, Mr. Lewis, not to put words in your mouth, your March 2nd request was any and all materials, et cetera, relating to incidents on 19th, 20th, 21st of February?
Nope, just the 19th and 20th.
Okay. And then...
Because I initiated the incident on the 21st, so I didn't care about that one at the time.
Okay. And then once you got your first incident report, you found out there was other corollary material that you then continued to ask for.
Mm-hmm. And I found out what a computer-aided dispatch is.
Okay. One of the things that the Sunshine Ordinance provides for is for the police department to help you find materials, name them correctly, label them, and I'm sensing a violation already on that. So that's aside, but we still need to try and work out that timeline as to what you got, what you asked for, when you got it, what's still missing. Is there anything still missing in your eyes?
Apparently.
No, the report.
Ms. Wallner, hold on one second. We'll come back to you. Yeah. So you're. Well, we'll get to that. But in your and please, no more outbursts from the gallery. When you're up here, you'll be able to speak. So let me rephrase that. Of what you asked for on March 2nd, have you received everything that was in that?
I have.
Okay. And what page is that, if someone can point to, what page is that in the packet?
Sorry, I'm a little
Actual
lost
wording.
now. Wait, so you received, which one did you, wait?
Okay, I requested information on March 2nd, and I received something that was responsive to that request shortly thereafter.
Right, so I'm looking on, so on March 3rd, that's when they talked about incident report.
What page are you on?
So I'm on page 2, gosh, now it's like marked out by the bottom. 278.
All right, thank you.
So 278, there's communication on March 3rd from, sorry, how do you say Johnny?
Jeff. Oh, I'm sorry.
Sorry, she?
She.
Referring to this incident report, the last three digits are 096. I'll just call it 096. And then he doesn't get back to you about 096 until what, like the 18th? So that's not the one that you got back immediately. The incident report.
Actually, no, I'm looking at the email. I didn't realize that this was going to be, that the timeline was going to be important. So I wasn't thinking about that when I came. But I'm looking here at my email, and it says, on March the 17th, I requested 096, and I had not yet received it.
Okay, so yeah, so on March 16th, he said that 096 was still pending approval. So
Right.
I think that's the last I see. Did you ever get that incident report?
I did, yes.
Okay.
But I don't remember exactly when.
Okay.
Chair,
Mr. Kohler?
I've got record, or I've got information in the packet and in my advice memo as well, indicating that it was provided to him on the 18th.
Okay.
And the first documented evidence I have of there being a request was just a response from officer or SFPD employee Z, Johnny Z, on the 3rd, acknowledging that there were certain CAD numbers and an incident report number. But that they weren't going to be available for a few weeks.
And then on page 271, there's a request for incident report, and I'm just wondering if that came from the complainant or if that came from SFPD as far as this record.
Oh, wait. What do you mean came from SFPD?
I'm sorry, I'm asking.
Oh,
we have a whole packet of information, and I'm wondering whose record this is, if this is your version or their version of the record.
Oh, the only thing it's pure speculation, but I'm thinking that the email on March 3rd, the first one we have, is in response to this request for incident report form.
Yeah, that one's dated 3/1.
So the one that's
So a
dated
3/3 response would make sense.
Right, so, but I'm just wondering because there's nothing marked in the internal use section which would have said when the request was received and when it would the documentation that would say, it's just not on there, so I wasn't sure who it came from.
There's no timestamp on it.
Yeah, there's nothing on it.
But it did provide an email address to respond to, so that makes sense how he was contacted by SFPD.
Right. I'm just trying to establish whether he sent it on the 1st or it's possible that you could have filled it out on the 1st and sent it on the 2nd. That's what I'm trying to figure out.
If I remember right, I think I sent that first one by mail, but
Okay.
I'm not sure.
Well, it's a handwritten incident report that you filled out, I guess, at the station is what it looks like.
An application to receive
Application.
one.
I mean, you might have printed it and mailed it in, I don't know, but...
Yeah, I think I printed it and mailed it in. That sounds right.
Yeah,
it's a request.
Before we get too much into the details of this, it looks like this is an application for for an evaluation on a 72-hour detention and treatment.
Sorry, the page before that.
These.
Wait. That wasn't provided to me during this process.
Yes, it was.
No, it wasn't.
Complaint packet.
No, it wasn't. No.
Then it was provided to you in our complaint packet. We send out our complaint packets. How you receive notice of this meeting?
No, I received notice by email.
There's a link
And
in
the
there.
email has an attachment showing you.
And I opened the
agenda and all
attachment,
complaint.
and it was 7 pages, and it didn't have that on there.
That would have been the agenda.
Yeah.
There are instructions. May I clarify?
Yeah.
I do
Mr.
send a
Clerk.
copy of the agenda, and there are instructions in the email stating that if you click on anywhere on the title of the item, it will bring up a copy of the agenda packet. There is a copy of the agenda packet right there for you to look at. Yes.
That's handy, isn't it?
So, Mr. Lewis, what our deliberations are based on the complaint you bring and what?
That's fine, I understand.
Yeah, okay.
Well, let me just, so I'd like to know why Candy Holder never responded to my phone call. And I'd like to know why the police didn't give me the incident numbers and the CDA numbers promptly when I requested. Is that hard enough to do?
Before we can even address that,
okay.
I think the task force should take up whether or not he requested public records. You know, these involve
incident reports are public records.
These involve medical records.
Incident reports are public records.
Mr. Lewis,
pardon me.
Hold on.
They also involve potential victims whose names are listed in there that have confidentiality as well.
Right.
So all of this needs to be addressed before you get into the meat of the issue.
Is whether we have jurisdiction.
And then another issue is, did you eventually get all of the requested documents?
Yeah.
Apparently not.
Okay, hold on. That's just a rhetorical statement. Okay, we're going to get some order in this meeting. Member Wolf.
So we have precedent in something like this, and it goes beyond SFPD. There was a case brought by Jason Grant Garza that went on and on for a very long time with him trying to get documents from the health department. They were regarding him personally. And the law under HIPAA, which is kind of the big federal law on health in the land, on privacy, very specifically notates and provides that anybody who is asking about records about themselves they're required to present them to that person. And the issue for Mr. Garza, as a side note, was he didn't have any identification, so they wouldn't release him the information. But the information we found out. We really did some deep research on this. So my concern here is that yes, I believe that all police reports, and we have been through this too in this task force, police reports are public documents. Now, the state law requires that many public documents are held in confidence. They're confidential. They have to be redacted. The actual document cannot be even revealed in certain cases, but the information, in other cases, the information on the document has to be held in confidence, and it could be all blacked out, all redacted, but you still get the document, right? So, I mean, there's many different cases in regards to this. The question here is you're asking for information about yourself?
Yeah.
Okay. And that is really, to me, the crux of the matter here. Whether or not there's other information that doesn't pertain to him, that information, however the law reads, for whatever authority or privilege it offers to that law enforcement agency to redact, they can redact. But all the information that pertains to the person himself after the fact, and it seems like in this case that it was after the fact, it was after the investigation was over, they were finally able to give him some numbers, some identification numbers, and so on and so forth. So correct me if I'm wrong, but the lawyers in the room, but that has been what, in my experience here on this task force, that we've found to be true. So I want to just get cleared up the question that our legal counsel has put forward with regards to are these public records or not. Okay, so let's determine that first, and let's get some provisions of law here to make sure that we're dealing in facts and not interpretations.
Can I ask a question?
Yes, testify.
I have a question for the complainant. So were these reports that were filed on you or filed by you that you're trying to get a hold of? Just because that is a fact that would contribute to what Member Wolf was just explaining.
Okay, so I'm not a police officer. I don't understand how these things work, but the police are the ones who did these reports. So somebody called the police, and the police came, and the person who called the police didn't do this report. Right. It's the police who did their thing, and then they filed a report.
So someone called the police and filed a report on you, and then the police created this report.
I'm not sure that's the way it worked.
What?
No, somebody called the police.
Eldon?
Sorry, I don't know if we can get into like who's like the
I don't
victim
think
or
we should.
suspect or anything
Yeah.
like that in this setting.
Okay, because the reason for my question is because Member Wolf was explaining that if the report is about you, that's when we're going to be giving the information.
How do we?
So
It's not necessarily true.
Well, I was a party in the.
Pardon me. I mean, there were several. I mean, I cited some case law in my memo, just because a report or there's something that is specifically about you doesn't. There are other routes to get it. I mean, if you're an employee and you want your personnel file, you could get that under the labor code. If you want your medical records, there's ways to get that under HIPAA. But I mean, just because you're the subject of a police report, if there's confidential information in there that warrants such redactions that it's essentially a useless document, it's still you don't have to provide that. It's an exception to the CPRA.
Is a domestic violence victim or something like that.
And in particular, on top of that, if for some reason if you waive a right of if you sign an actual waiver to sign. The case law that I'm actually referenced in here, let me see which case it is. I think Black Panther Party versus Kehoe. If you waive your privacy rights to a certain document to obtain it under the CPRA or under Sunshine, that waiver applies to anyone else who then wants to make a Sunshine request for that document. Right. So, I mean, there's a lot at stake in doing so, and when people come here looking for documents that are quasi-public records, I suggest that we steer them other routes of obtaining it that don't jeopardize their privacy rights. And in this case, I don't even know if it's worth debating because we're hearing that he did get the document at issue. So maybe we should just be asking SFPD whether or not there are any other documents they haven't provided him. Mm-hmm. Then we could determine whether or not they went through the proper process of withholding those documents, notifying them that they were withholding those documents, and giving them a basis for the withholding.
Okay. Thank you, DC Acola. Member Eldon and then Member Wolf.
I actually am not sure myself, so I'm asking the city attorney and the other lawyers here. How do we reference, when someone's looking for police report information, how would we even reference whether or not someone is the suspect or the victim or whatever the terminology is that we would use? And is that something that we can reference in this setting if it's not public information? Or
I think the best way to address that without addressing it head on is maybe just ask the department if there's any reason, if there were any privacy exemptions, if that was a basis for the withholding.
I guess the course of action you're suggesting, like, I understand why you're saying it, but it really removes us from having any role in trying to provide transparency here, it sounds like. So I'm like,
I think he means we ask them what the exceptions are, and then we can determine if those were validly applied.
Okay.
But we ask them first to do some of the work. So
okay.
Member Wolf first, and then Member Wolf.
Actually, can I ask a question real quick?
Hold on one second. Let me just get these two, then we'll come to you, Mr. Lewis.
So, Mr. Lewis, I've got a couple questions for you.
Mm-hmm.
First off, you requested documents. You didn't receive them within the 10-day period, but you now have all the documents that exist related to your request according to the police's word that they just gave a few minutes ago, correct?
No.
Okay, what is it that you're still looking for?
Ms., what's your last name?
Ms. Walland.
Ms. Walland mentioned that there are documents from February 18th. And that's the first time I've heard of any documents from February 18th, even though I've asked repeatedly for any and all documents related to these incidents.
Okay, so one thing you're looking for is potentially more documents related to these incidents.
Exactly.
Is there anything else you're looking for from us today?
Yes. I'd like to know why Candy Holder never returned my phone calls.
Who is that?
She's the woman who apparently was in custody at special victim units of these documents and couldn't give them to me because I wasn't told why.
So that may contribute to a lack of a city agency helping assist the requester for their documents. But in many ways, it sounds like you have frustrations with the experience you went with through the police department, and that when you spoke about these frustrations with City Attorney Jerry Threet, he recommended that you file a complaint with the Sunshine Ordinance, correct?
I think so, yeah.
And I'm curious, so unlike, forget what I was about to say, there are multiple ways to file a complaint when you have an interaction with the police department beyond the Sunshine Task Force. Have you sought out remedies around your lack of satisfaction with the experience through other entities such as the Office of Citizens Complaints, etc.?
Yes.
Okay. I was just trying to ensure that you were following a parallel track.
My complaint with the Office of Citizens Complaints does not address my dissatisfaction with how slowly the police department provided records to me. It does not address that issue. So no. So the answer is no.
So that's what you're seeking for us, is about the timeliness of the record response.
Yes.
Great.
Okay. The second member, Wolf, you had a question.
So, yeah, a couple of things. One is I agree with legal counsel that just let's make sure that what Member Wolf was trying to do is assure that he got the documents that he wanted or that he requested. But I do have to say, from the beginning of this case, from the time that you had spoken to DCA 3, you had specifically asked for documents on an incident on the date of March 2nd only.
No,
the fact that you
February
may
20th.
have learned, wait a second. The fact that you may have learned that there may be more documents for maybe other issues not related to the one you were looking for is not what's before us today. And I'm not going to go on a wild goose chase to find every single document that may be related to you. You specifically had a discussion with our legal counsel about this, about an incident on March 2nd. So let's just
For me?
deal. Yes.
Okay.
It's in writing. It's an email from you.
Member Wolf, I think you mean February 19th and 20th. He wrote the request on March 2nd.
I'm reading it right here. It says, I would like to initiate a complaint against San Francisco Police Department. I request a copy of my incident report 096 on March 2nd, 2016, because I'm preparing to file a complaint in district court.
The incident was on the 19th.
Okay. Right. Right. But what I'm also saying is, as part of that complaint, he referenced February 19th and 20th. He's now found out there's other stuff on February 18th, which you'll probably have to file a separate request for.
Okay, I got what you're saying. So you're saying that he didn't receive the complete package of documents relating to 096.
Yeah, I think he's found corollary material around that.
Okay.
But this goes to Section 21C, where that person should have said, oh, February 19th, 20th is great, but there's also stuff on February 18th, and here's where it is, here's the number.
Okay.
The custodian of records would need to assist him to find that. So, I mean, I'm just as a quick, aside, I'm sensing timeliness and 6721C violations based on what I'm hearing here, if indeed we can proceed down that road, which is still a question that's up in the air. Let's do rebuttals from Mr. Lewis first, and then from actually the other way around, isn't it? My apologies, Mr. Clerk. Mr. Lewis, if you can take a seat, and Ms. Wallen, if you could approach and just give us a summary of anything else that might help us. Any closing statements?
Does this contain the police reports or no? For some reason, my packet doesn't contain the
What was given?
police reports. Okay. So, my understanding is that he sent a request. Do we have the initial request?
We've got page 271 in that packet. It should have it.
Okay. Okay, so he listed the date and time of occurrence as Friday evening, 2:19, to Saturday afternoon, 2:20. In the request that's dated 3/1. So my understanding is that that report was located by the record room. It does contain sensitive information. It was sent to Special Victims Unit for review and redaction. And that when he received that report back, within that police report, it listed a case number in the text of the document, but it wasn't in the related case number box up in the thing that would have caused it to flag a report that had an occurrence time that started on a different date. So when he saw that, he requested that report, then that report was subsequently given to him. And I'm just saying the reason that it was probably not given was because the time of occurrence didn't fall within the time frame requested.
And that second incident was the February 18th?
It started on February 18th and ended on the 19th, and that he was given that report, I believe, on March 24th. And that's all the police reports we have related to that incident.
That seems like a pretty clear timeline. Anything else you'd like to add in closing?
Do you have any other questions? My understanding is he's gotten all the documents from us, and that any time lag over the 10 days was strictly to, protect him, because these things are released publicly. You release it to one person.
Gotcha.
You have to release it to everyone. If you want to file a lawsuit, you can subpoena the records, or you have other things to go. But if you do a public records request, you have to be careful.
And when something comes in and that gets sent over to crime victims unit, that for redaction, that obviously adds time to fulfilling the request.
Yes.
Okay. All right. Thank you. Mr. Lewis, if you'd like to, you have 3 minutes to do your summary.
My rights were absolutely not respected. I never authorized release of this 5150, and I am furious that it is here right now. This is my medical record. This falls under HIPAA. I did not authorize this release. I didn't get this from the police, and this is the first time I'm seeing this from the police. I didn't release this, and I'm furious. I'd like to know who authorized release of this form. This is part of my medical records at CPMC. I am furious.
What form are you talking about?
Application for 72-hour detention for evaluation and treatment. I didn't even get this from the police. I had to get this from the hospital. And now they're releasing it to you people, and now this is public record? I'm sorry. I don't know what is going on here. I know my name isn't on there. But do you think anybody is not going to guess who it is? Jesus Christ. I'd like the police department to send me my application for 72-hour detention and hold, because obviously somebody's been doctoring it to hide information. Jesus Christ. And I'd like to know what information they're hiding from me, because obviously they're very good at that.
Mr. Lewis.
I'm sorry.
Mr. Chair.
Yeah, Mr. Wolf.
Can we find out how this document ended up in,
Yeah,
in
Mr.
the
Lewis,
record?
Take a seat. Let's get to the bottom of this. Mr. Clerk, any insights?
I would need to check to see who sent it to me. I actually did the redaction myself.
Oh, so
I'd like it removed from the
Lewis,
public record.
Yeah, take a seat, please. That's disturbing that you had to do. That it was sent to you without being redacted.
That is correct. I did the redaction myself. I would need to check my files to determine who was the provider of that document.
Are there any other copies
Mr.
of the
Lewis,
document?
sit down until we're done to have you up here again. We will do the best to comply with what we want here.
I have a question.
Yeah.
For Mr. Young. So the document that is on page 271, is the document on page 272, was that included as a supporting document by the person who filled out page 271? I only ask because on page 271, there is a reference to the 72-hour detention. Though I would be surprised that that person would include their own 5150 to support their
I
request
can't
for
tell
record.
from
You
looking
can't
at the
tell?
documents at this time.
Okay.
But we do put disclaimers on all our applications that anything submitted to the task force is considered a public record, and the administrator will not perform redactions, even though I did do it at this time.
Thank you.
Yeah, because the next page, it has a different header, State of California, HHS. And then it's...
Let's not try to guess.
Yeah.
I would appreciate not doing it. I'm a social worker. I've dealt with a lot of these documents before. I'm a little concerned myself.
Just as a matter of course, can we have this removed from this electronic record, at least down the road? I would think that would be a reasonable request.
It's in the agenda now.
Yeah, it's already public.
So if he
And this conversation about it is also a record.
That's
so
right.
Yeah.
I would actually leave that up to legal counsel to advise us on that.
What to do. Okay.
And I would also be concerned that if Mr. Lewis wants to bring a complaint in another venue about what has occurred, and then the document is no longer there, even though he doesn't want it to be there, it would make the record very unclear as to what happened. So as much as I would like to be removed, if he does want to file a complaint against someone about if something improper has occurred and it's missing.
Yeah.
But we could maybe try and do something where it's under seal, and I'm sure the DCA can look into that for us.
Yeah. Even though it's heavily redacted because of where it appears in the agenda.
It's clear who it's about.
Yeah. All right. That aside, let's try and get back to where we were. We've had closing arguments. Are we feeling any motions here? And if so, Member Wolf?
Well, we still haven't gotten both the complainant and the responding party on the same page as to whether or not there are more documents. And from the complainant, a document that's actually in the file was a new document that he hadn't received before, which is what we're now talking about. And so I feel like if there's anything we can do to sort of move that ball forward before making decisions around what violations may have happened would be the most effective way to ensure that the complainant receives all documents related to his request.
Do you have a motion?
Member testify? Was that a motion?
Yeah,
No, that's not a motion. It's the suggestion that we have some sort of conversation with the two of them still in this process to ensure that they're closer to the same page. But the more we talk about these issues, the more likely more confidential information will come out. So I'm kind of at a loss.
Okay. Well, before we address that, just my thoughts is, there's a 10-day statute which was not met. There was a failure to help, which was not met. Those are certainly two violations we could entertain and take a vote on. Now, if there's more documents that we can identify that are part of the original complaint, and I don't think they are. I think the document that is missing is about something on February 18th, which falls outside the realm of what he originally asked. Am I correct in that, DCA Cola? Or is it...
From what I can see in the records, I possibly, but to be honest, these additional documents that the complainant is upset about for being included in the record,
Not those.
I mean, they're not included.
No, not those.
They're not really responsive to his requests.
Yeah, no, the documents are other documents that he hasn't received yet. That's what I'm referring
Well, the
to.
police department has already stated that they provide everything that was responsive.
They did say that. Ms.
And-
Lewis.
And you've acknowledged that you did receive the report,
About the 18th.
the incident report.
Not at the 18th, no.
So that
Well-
still is outstanding, according to the...
No, there is only one report. I think it was just a discrepancy in the dates that everyone is talking about now. Is that correct?
No.
So you believe there's multiple reports, and you haven't received one?
I received all the reports for the 19th, 20th, and 21st. Ms. Wolin has mentioned the 18th, and that's the whole problem I'm having. I want to get all of the reports about me, and apparently there's one on the 18th too. And I can't...
Could you get up and speak in the mic and just clarify whether or not there is an additional report that he hasn't received?
Well, she said it, so...
Ms. Lewis, let Ms. Wallen approach. Mr. Kohler, you make a good chair.
Thanks.
So my understanding, as I stated before, was that he requested the original report, and that's the only reason I could think that that document didn't pop up. It popped up in the text of the report that he received on the 18th. When he requested that report, it was given to him. The time of occurrence sometimes will span more than one day on a police report.
You mentioned it was given to him on March 24th. Do you have an email record or evidence that it was emailed to him or anything that can corroborate that?
I know I gave you guys a packet, so let me see.
So while we determine whether this last document has received...
So on the 18th, we say attached. Please find your report. That was request number 1. Request number 2.
So while she looks that up, Member Wolf, you're going to mention something?
Yeah, I was just going to mention that 6725D speaks about receiving responsive public records on an incremental or rolling basis. So when you start a request, if there is any additional as time goes on, they're supposed to automatically send you these items. Here, because of the mistake or indexing of how additional records that were attached to this incident, it wasn't the police department that picked up on it, but it was the complainant here that picked up on it, asked for those additional documents, and now by testimony we're finding out that there's more documents. So I just think that there's a little bit of failure on that part with regards to receiving responsive documents on a rolling and incremental basis.
All right. Ms. Wallen, did you find the reference?
Well, my testimony is not that there is additional documents. My testimony is that he has been given the documents. I do not work in the record room. I do not know the process in which they use to locate it. But if I was to receive a request for a certain date and I looked in the computer and I saw a report for that date, I would fulfill that request for that date, because police reports can span a certain amount of time. If you looked in the computer, it would show the incident report as started on another date.
If you don't know whether that was sent to him, why are you saying that it was?
It was sent to him
And-
because it
and
was
that
listed
is-
in the narrative of the police report. Then he requested it, and it was sent to him on March 24th.
Member Eldon?
So you're saying that you have sent him all materials and there are no other ones that you haven't sent him?
Yes. I was trying to clarify why it might have been
there's
missed.
basically no explanation we know of why there would be any existing reports that he wouldn't have right now. That
For the time frame and the location that he requested, because that's what's been researched.
Okay, so should he file an additional request, or do we need to somehow otherwise consider this for February 19th or February 18th or any other dates in order to get that?
No.
Member Canada?
There's an email in the packet dated April 11th.
What page, please?
Page 268 from Johnny Z.
Reading same.
To Mr. Lewis, saying that there's a total of 5 CAD numbers listed from the 19th through the 20th, and they list the CAD numbers, and then they list 2 incident reports were sent via email. But then they say 3 of those 5 CAD numbers, you can obtain those reports through DEM. So that would lead me to believe that there is more information out there.
I might be able to add a little clarity with that. So they referred him to DEM, and they manage the CADs. That's a computer-assisted dispatch, and that essentially is just how it's an electronic document that stores calls for service to particular areas. It might not actually contain any more substantive information other than indicating that there was a call for service to that particular address.
So weren't those same CAD numbers in an earlier email? I'm trying to go through all these emails now.
Yeah, and I believe that same information was included in an earlier email directing them to DEM for those CADs.
And Mr. Lewis, did you ever
Page 264.
go to DEM for the CAD numbers? Have you received that information?
I'd have to have the numbers, but probably.
Okay.
Yeah, to members, when you address respondents and complainants, have them approach the mic so it could be entered into the record as far as their response.
Mr. Chair?
Yes.
I would just like to say I'm reading the email thread through here, and starting on page 264, where to me it gets very responsive. If Mr. Lewis made his request on March 2nd, on the very next day, he gets a message from Officer C stating, here there are reports. I found some. Okay, here are 4 CAD numbers and an incident report number. Okay, which so to me, I cannot see that they were not responsive. They were responsive, and they were helpful in that respect. Did he get the documents in a timely manner is a different question. If they have a special process that things have to go through, and it takes a certain very specific period of time, that could be considered reasonable. Just throwing this stuff out there, not trying to adjudicate this at this moment, just getting my thoughts out here. So I think we need to kind of start there, okay? So from March 3rd, they were responsive. March 2nd, so 10 days from March 2nd, okay, is what, March 12th, right? Okay. Did he receive any documents before March 12th is really the question here.
No.
And if he didn't receive documents by March 12th, which is the turnaround time for a sunshine request, I don't know about any other request for any other area of law, but for the sunshine ordinance that he's here today for, it's a 10-day turnaround, unless it's voluminous. This is not voluminous. So I'll stop there for now.
Okay, Member Koh?
Through the chair, if I could. If anything, they failed to invoke an extension, and they failed to specify as to why they needed additional time. But that's all I really see with this one here.
And possibly 21C not helping him identify additional. I mean, there was, I wish Johnny Z was here. That he'd be nice to talk to him because he's the one that was fielding a lot of these requests. Member Wolf?
Yeah, I have a question.
And just in the interest of time, let's try and get to a motion after this comment.
Yeah, so my question's for the police representative. Do you know whether the documents that the complainant received, I guess he did receive them as public information, not as a party to the incident?
I believe he received them as public information. No.
Didn't he fill out a incident report?
Request, yeah.
On page 271?
like the documents that he requested or that he received are not part of our packet. And I don't know whether that's just because they're standard not part of our packet or because they're not public documents that he received and received because he's a party to them. But I'm trying to ascertain whether this is really a public records request that he ended up getting or whether he got records related to his case through a different process that sort of intersected with the public records process.
If I can interject just for a second, give you some factual information here. On page 264, Officer C tells him that he's attached a form which you can fill out along with the following CAD numbers. And I imagine that that is the request to get the information. I don't know whether that attachment is a public records request,
right,
or whether, as you're saying, is it a request of the records pertaining to him directly in another venue.
So are you saying that
the
attached document is the one that he filled out?
Yes.
The request.
That's what I imagine.
But if the email that Johnny Shee sent is from March 3rd, but the date on the request for incident report is March 1st. So I don't know how that. I mean, he might have attached the same document that Mr. Lewis had already filled out, but.
Well, on that March 1st document, he lists his email address, and then Mr. G probably sent him an email. And
So
this was a response.
he must have sent him a different document then. He wouldn't,
March 3rd.
a different form. He wouldn't have sent the same form.
Not that one. The form generated the email from Mr. Z.
Right, so he said that this was the document that Mr. G sent to.
Okay.
But it wouldn't have been this form.
Yeah, I don't mean to get into the weeds here, but
we need to move this.
I would just say let's not try to get into the detail too much, as our esteemed colleague was saying, that we don't want to make anything more public than it already is.
Also true. So would anyone like to propose a motion?
Let's see. I would say I would move for violation of 67. I'm not trying to fish here. I'm just trying to look at what the facts are. I would move for 6721C and 6725D.
Those are the two I have here as well.
And are those for the 10-day response time and for actively assisting?
Yes.
Okay.
Yes. And for the role, incremental. Yeah.
Yep. But we didn't. Is it 10-day within that, or is that not?
No, that's not within the 10 days. That would be under 6721.
Just 21. Right. B. So would you like to amend that to 21B and C? And
Wait. Hold on. You know, it's hard to do 6721, and I'll tell you why. Because the police department was responsive to him within 1 day.
They were. That's true.
Okay, they may not have had the records specifically, but they actually had the number of the ID numbers of those records.
And you could say that the fact that it went to special victims was invoking an extension.
But it's part of process.
Yeah.
Their own process, and we're dealing with, law enforcement matters with regards to information is held at a different level than all other public documents. So
you want to just keep your original motion as it was?
Well, the problem is that under 6721C, a custodian of public records shall assist the requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall, when requested to, provide in writing within 7 days following receipt of a request, a statement as to the existence, quantity, form, nature of the records regarding to, as far as I'm concerned, they're not in violation of that.
Because in that material you did receive, it identified that extra document.
The materials were identified, maybe not all of them, but that's where 6724D comes in, because somebody wasn't paying attention to all the other additional documents
follow-on documents.
following up on it. Whether they were before or after, it's incremental, if not rolling.
So am I hearing that you're making a motion for 6525D?
Yeah.
Alone?
64, no, I'm sorry.
6725D.
6725D.
Is there a second?
Second.
All right. Is there public comment on that motion?
Peter Warfield. I'm not a party to this and not particularly familiar with it. So certainly I think that the motion makes sense. But I want to comment on part of your process, part of your discussion, which may help to shed light on this as well as other occasions. At one point, I heard your deputy city attorney, Mr. Cola, say or ask, did the complainant request public records? And then later he said, he referenced quasi-public records. And it's stunning to me that there doesn't seem to be a basic understanding of what a public record is. So my understanding of a public record is basically anything that the government holds. The real question is whether some or all of public records, in particular instances, are disclosable or not disclosable, whether they are exempt from disclosure or not exempt. That's crucial to any discussion about the core of what you're in business to do. Now, I didn't find a definition of public records in the Sunshine Ordinance, and that presumably means it's relying on government code, the Public Records Act. And that says the following, under definition 6252E for Edward. Public records includes any writing containing information relating to the conduct of the public's business prepared, owned, used, or retained by any state or local agency regardless of physical form or characteristics. Public records in the custody of or maintained by the governor's office means any writing prepared on or after January 5th, 1975. And that's where I see it stops, and it goes on to the next subject, which is what's a state agency defined as. So it's very disturbing that your legal counsel is using phrases like quasi-public records and asking whether what was requested was a public record, and doesn't seem clear what is a public record. So maybe we should ask him what he thinks is a public record. I don't think that the complainant was asking, for what somebody was storing in their shoe as to where they were going to go shopping this afternoon. So in any case, I think that's certainly important here. I think in general you're on the right track. But you certainly should ask your deputy city attorney what his definition of public records is, and quasi-public records. Thank you.
Thank you. Seeing no other members of the public in the room, public comment is closed.
Just to clarify, or be sure I have it correct, this is a motion to find a violation of Administrative Code Section 67.25D for failure to provide assistance and failure to provide documents in an incremental form, incrementally.
Yeah, I would just strike that, not the failure to provide assistance, because that would be under 6721C.
So what would be
So it'd just be the rolling, didn't provide.
providing documents on a rolling basis?
Right.
Thank you.
So,
Member Wolf?
Why did you decide not to move forward with the 6721C?
Because on March 2nd, the request was made. On March 3rd, the police department was responsive with actual ID numbers of actual documents that exist that had to be processed for release. So the custodian knew where the documents were, advised the requester that they had the documents, and actually told them that other documents were in a different department.
Right. So I understand all of that, but my concern, and maybe it doesn't cover the sunshine because he hadn't filed that paper, which isn't exactly a normal records request in the first place, is that paper was filed after a conversation with this, I don't have Candy's last name up in front of me,
Holder.
Candy Holder, and attempting to obtain numbers related to the records prior to that, and was unable to for whatever reason, which his testimony conveyed. And so there's this process that he, perhaps during the actual incident where he was trying to obtain numbers that he didn't receive, which he did speak to being frustrated by. And then I don't know whether Candy Holder was the responding officer or an officer that he spoke to after the fact, but at the point that paper was filed, we see a record of responses being responsive, but we do have testimony to him feeling like he wasn't being helped prior to that.
So just through the chair, I'm just a little confused. So are you saying that there was a request made prior to March 2nd?
Well, it doesn't look like it was made in the form of a written request at all.
But that wasn't the complaint that was presented to us. The complaint was presented to us was documents made on a request of March 2nd. If you look in your packet on page...
Sure. I think there's a
273
incident request, a handwritten one on March 1st. Does that rise to a public,
Right. There's that's the starting point that Member Wolf is referring to, and I'm trying to ascertain whether if prior to that request the staff is not helping someone with obtaining the information related to the same request that you're now filing, should not that failure to assist before you actually put the complaint to paper still be part of the record of the department's relationship on this issue?
So Officer Hilder is responsible, works at Special Victims Unit. When the record room received the request, then they send the request to her for release, redaction, authorization to release as the investigating division of the police department. But she would not be responding to people's phone calls. That's Johnny's job, and that's what he did. It's her job to make the authorization to release it. It's not her job to respond to requests on the status that should be going through the record room. So no request was made to her directly. The request was made to the police department, records or public records, and then it was sent to her for the approval to release.
Okay, that's helpful. I see more of the argument against including the 20, whatever.
Okay. All right. I think I'd like to take a roll call on this.
On that motion, Member
Hold on one second. Member Moss?
Sorry, Member Wolf, can you just explain to me one more time why we're going with D? I just want to make sure I understand it.
So it is my it's my belief here that it is incorrect to find a violation of 6721C because the responding officer to Mr. Lewis was within the 10-day period.
I understand that. Gotcha.
Okay.
I'm following you there.
Okay, so with 6725D, there were additional documents attached to this particular request that were not provided beyond the 10 days, that were existing beyond the 10 days that he found out about later. Okay? For the 18th.
The second incident report.
And so there should have been a rolling report, like a flag, that when this name or this incident comes up, and what we had heard from Ms. Holland,
Walland.
Walland, is your name? Sorry. Ms. Walland, I'm sorry, Lieutenant, right? Lieutenant Walland, is that some of the way the documents were filled out were possibly not correct.
Okay, so the documents from February 18th were not connected to the documents from February 19th that were given.
They were directly connected to them, but the reference
they weren't the
to
same.
the reference to it was contained in the content and not in a special box.
Okay.
On that form.
So they weren't the same documents.
So nobody would have noticed that it would have been flagged. I get that, but that's a fault of their system.
Is there an indexing violation here as well, potentially?
I don't
think we have enough information.
That's getting too deep in the weeds.
Okay.
That's not the same as indexing as
Okay.
what we.
I think this is probably the cleanest violation that we can find.
Just to make sure I'm just covering my bases, and 6725B is not appropriate here.
That's the initial 10-day. They did respond within.
That's if they needed to go to.
But that's only if it's in a voluminous nature. And this was a voluminous.
Okay, or the need to consult with another interested department. So that's when it went to SVU, and that would be the other interested department, and then it went past the 10 days, and he was told it needed to go to SVU, but there wasn't an ask for a notification of extension.
When was he asked to go to SVU?
Let's see.
Or he's told it would be now become an SVU case.
Yeah, but was it within the
department in this context means other city department? That's just another division within the same department.
Right. Okay, gotcha. Then, understood.
Thank you.
Okay.
Cool. Are we good?
We're good.
All right, let's have that roll call.
On that motion, Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Member Bruce Wolf.
Aye.
Wolf, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher, absent. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. The motion passes.
Is there more we need to do on this?
Possibly refer it to a subcommittee for either compliance or EOT. But actually, what I wanted to see, is there any advice we can give the complainant as far as what to do about that other incident that we discussed earlier, where you can direct him?
I would say I'm not a lawyer and I don't know everything about this kind of stuff, but I think that, at that point it's a legal matter.
Okay.
And, there are other avenues that DCA Cola had mentioned, and I think that I don't think it's appropriate for us to suggest what those are. I don't want to be incorrect about it or send them on a wild goose chase or down a rabbit hole.
Okay. I guess it's outside of our purview. And as far as referring it to another committee, I think we've...
I'll leave that up to you.
Yeah. I don't see this for referral at this point. Possibly. Everything ends up there. Are you volunteering?
But I mean, we don't need to refer this whole issue formally to the city attorney's office to look at what happened.
Yes.
Ms. Lewis, please hold on. No, that's, as Member Wolf said, I think that's something that he'll have to do on his own to get to the bottom of this. I think us referring him may be inappropriate at this point. I think it falls outside of what we're here to do. But that might be an option that he would want to take, since you mentioned it.
I have no idea what the liability is for this now that we've seen it and we've heard it. So,
Yeah.
I mean, I feel like legal advice on this would be useful, but I don't know this is my first
that's
meeting.
certainly one of the places he could visit.
I mean, for us is what I'm saying as well.
Yeah. Yeah.
We'll talk about that in a short while.
Sure. Sounds good. Just want to make sure.
Another thing to add to your list, Member Muss. All right.
Mr. Chairman, before we move on,
Yes.
I'd like to state that regarding the document, the redacted document, that was provided to us by Mr. Lewis in his initial complaint. In addition to that, he submitted a copy of his ID, which I did not include in the packet.
Oh, I see.
By me?
Yes, it was.
And you have email evidence of that?
Solves a bunch.
Yeah. Okay. No, I trust you. You might want to reply to that email so Mr. Lewis is aware of that.
Yes.
Okay.
Would you like me to remove it from the file?
I think it's public.
I can
Well-
leave a redacted version in the file and leave it at that.
It's
that.
I would ask DCA call.
That we need to ask the DCA, but
I can place it in the file in usually in this matter with lawsuits, I would put an additional envelope in the file and marked it confidential and leave it in the file.
Mr. Chair, can I ask that we defer this conversation? I'm going to ask something later in our general business section about this.
Okay.
I think might.
So to be continued on that note.
Next on the agenda. Item number 11, file number 14030, amendments to the Sunshine Ordinance Task Force complaint procedure. If you will note on page 284, I have provided a summary of your last meeting's amendments to the complaint procedures. I mentioned that I would do a rewrite based on your suggestions, and I have included it. After we review that, we should begin any additional review of the complaint procedures with Section E.
What page is that?
$284.
284 is where he says to start review of Section E, and then we jump to Section E.
On page 284, I provided the list of the amendments made at the last task force meeting. There was a request that I rewrite certain sections, which I have done, and I have listed on this page. After you go through those rewrites, we should begin any additional review after Section E.
So just for the members of the task force that are new, this is something we've been working on. It's a work in progress, probably for the last year. And every meeting we attack a certain piece of it. I'm going to give us 30 minutes on this at most at this point. Actually, let's make it 20 minutes till 8:45, at which point we put it to bed and continue it to the next meeting. And it's really, part of it is procedures, a lot of it is, clerical. So if you have anything particularly substantive, we can take that up perhaps at the next meeting, given the lateness of the hour.
Yeah, just as a point of information, some of the items I want to discuss in the number 14, I really would like to have legal counsel be here.
Okay.
And I know what time, I'm not sure what time.
He's usually here till 9.
9,
Yeah.
okay. So I just want,
but since
making that request.
Since he volunteered for the EOTC, and I think I heard that on record, we might be able to get him to stay a little bit longer. Very convenient. We'll get you a special mic, put it on your lapel. All right, I think that would...
I'm a little, this is I'm not sure how substantive the work that you've done since you started this has been, and I've not been following this specifically. I'm a little tired and not sure I can get through all of...
I agree.
There's something specific that you wanted to discuss?
How about this? How about a motion to continue this item?
I move to continue.
Second.
And we'll be prepared the next meeting.
Let's take that with objection. I agree.
Public comment?
Public comment on that continuance.
Previously, I've counted about 8 times that this has been on the agenda. Many of the times it's not been discussed at all.
Mr. Warfield, I'm going to stop you there. As I mentioned, this is a work in progress. It's not something that's
I understand, and the agenda has not been clear as to which sections are done and which sections are being considered.
That's a good point.
Even now, I don't know if E is the 2 paragraphs on page 289, or whether starting consideration means you're going to go from here to the end, or what you're going to do. It's not really clear what you were even proposing to do. And I think, to be fair to the public and yourselves, there needs to be clarity. If you're only going to start from E, then say it in the agenda.
Good point.
And this continual putting off of the activity of this, as well as not following Roberts and putting old business before new, meaning this should be early on the agenda, means that people like myself come over and over and over again, and it's now 8:27 p.m. I've been at this meeting 4.5 hours, and once again, it's being put off. As far as I'm concerned, that almost makes it as though your notices of discussions aren't even valid notices if you're going to have most of the time abandonment of the discussion before there's even anything discussed. So I certainly think you should give due consideration. You should give new members, old members sufficient time, but you need to be fair to everybody and give reasonable notice and not just put it on every agenda and then abandon it. And I think you need to be very specific about exactly what you have done and what you've not done and what you are planning to do and so on and so forth.
As you mentioned earlier. Noted. Thank you. Mr. Clerk.
And I also think there needs to be a break 2.5 hours after the last one.
Thank you, Mr. Warfield. Part of the reason we're continuing this is to have the services of the city attorney, which is something that we're constrained by. But, Mr. Clerk, if you would actually, that's a good suggestion by Mr. Warfield, just reference where we are. You can take a seat, Mr. Warfield.
I wanted to finish in my remaining 45 seconds. Section E is a way of dumping and hiding and concealing and delaying requests for reconsideration. In all my years, 20 of filing complaints, only once, very recently, did I request a rehearing. And then I noticed that your existing rule is completely unfair. You say a rehearing can only be considered if there has been, you can only appeal an order of determination. But then you turn around and you don't give an order of determination when you deny the complainant. In other words, that means I can only complain, I can only ask for a reconsideration if I won? It makes no sense, and it's certainly not fair. And it's partly because you're not following your procedures and issuing a document with every decision.
So, Mr. Clerk, if you could reference where we're going to pick up the next time for that item, and we'll talk offline as to where it appears in the agenda.
On the motion to continue the matter to the call of the chair, would you like to pass that without objection?
So moved.
The matter passes without objection, with members Copra and Fisher being absent. Item number 12, approval of minutes for from the Sunshine Ordinance Task Force May 4th, 2016 meeting. Are there any proposed amendments or comments on the minutes?
Did you get Member Pilpel's last set of changes?
Yes, I did.
Okay. Anybody have any?
I just have a question. Is it appropriate for people who can't
That's a good
attest
question.
to the accuracy of the minutes to vote on it?
It is a good question, and yes, it is appropriate. You may not pass on that vote, as strange as that is. Member Wolf?
So I would just say that those members that were here for those minutes should review them and make sure they're to form and to quality. Make sure that they're, whatever happens is there, that kind of thing. Because we'll have to rely on you.
Yeah, Mr. Young, could you just restate the position for the new members of voting on minutes?
Basically, it's already been stated, you are not allowed to abstain on the vote for the minutes. We do understand that you were not present at the meeting. You may not have an understanding on it, but in a way, you're just stating that you're not requesting any changes to the minutes.
And we can reconsider if there's any changes that need to be made. We can bring them
We
back.
can always submit revised minutes if needed.
Yeah.
Are there
So
any motions?
I move to approve the minutes of May 4th, 2016.
Second.
The comment.
Can we take that without objection?
Public comment.
Public comment?
Peter Warfield, the minutes are required to, in the words of the ordinance, I believe the word is summarize public comment. And I don't know what is meant by the summary that's given on page 310 under public comment for item 3. Peter Warfield comment should be commented on the testimony of both the complainant and the respondent. I don't know what the content of that is. I don't know what Mr. Warfield might have said about both of them. So I think it would be reasonable to put something of substance there, as you have apparently done for example, Ray Hart's. Thanks.
Thank you. Seeing no other public comment? Pass without objection.
And motion passes without objection with members Copra and Fisher being absent. Next on the agenda, item number 13, administrative reports, complaints and communications. In regards to the second item, there is a hearing schedule upcoming for the June 21st. We have the Compliance Amendments Committee. July 6th is the next Sunshine Ordinance Task Force meeting, and July 11th is the next EOTC meeting. For the 21st meeting, I am hoping to get volunteers for that meeting at this time. Member Eldon is currently listed as the chair. Member Fisher has indicated she is able to attend that meeting if you need her, and we do need an additional volunteer.
So this
Which committee is that?
This is the June 21st Compliance and Amendments Committee, on the back of which will follow most likely several complaints as well. That's the structure we've been using. So, Member Eldon?
I'm going up for my confirmation hearing for the Board of Supervisors on June 9th, so if that goes well, I will be available. But otherwise, if they decide not to confirm me, then
you'll be a holdover.
Then you'll still be a holdover.
Will I be for that long?
Yes, you will.
Okay.
Unless they replace you with someone else, you are currently a holdover.
Nice try. Nice try. All right. That is, it's a 4 o'clock meeting. Well, what day is that? Is that
That's a Tuesday.
Tuesday. And typically, the first hour of business will be compliance amendments, and then the second hour will be hearing new complaints, kind of like the ones we decided on here.
And I believe after our next meeting, after we select officers, that we will be, whoever the new chair is, will be polling the members to see which committees they wish to sit on. But until that point, I just need volunteers to
Right. So
cover our
this is not cemented in stone, but we're going to have Member Fisher, Member Eldon, and need one other to jump in on that one meeting, and then we'll, on July 6th, once we elect the officers, we'll then go down the chain and also put people in subcommittees as well.
Maybe to whet people's appetite, explain what Compliance and Amendments Committee does.
Perfect. Please do, Member Wolf.
Thank you. Throwing it.
On that agenda, I believe we have a follow-up on one item that was heard by the task force and referred back to the committee to determine if they have complied with the order of the task force. And there'll be 3 or 4 new complaints like we heard today, starting with the review of the documents and basically conducting a full hearing on the matter and making a recommendation.
So generally, Compliance and Amendments Committee will, after an order of determination has been made, if there's some request that was made to be fulfilled by the respondent, then gets kind of reviewed by the Compliance and Amendments Committee of whether it was complied with properly and to the order that this body had made a determination on.
Yep.
And Eric, Mr.
It would be super helpful to have someone qualified as a lawyer on that committee.
Yeah,
I think I did
You
hear
guys
it
have already
earlier.
been great in this one.
I did hear it earlier volunteering.
I'm interested in being on that committee. I'm not available to leave the office early that day on the 21st, but I am very interested in being on that committee.
Yeah,
That's
that would
good to hear.
It would be
Is anyone else
great
like to
service to the public.
stand in
to
just
have
for
a
that
lawyer.
day? Doesn't.
Let me check my schedule.
I can be there.
You can be there?
Yep.
All right. Would any of the new members like to stand in that day? We have 2 experienced members on, so.
I haven't done this a full year yet, but I suppose.
All right. Okay. All right. So Member Wolf, Member Fisher, and Member Eldon will be there for the 21st.
That'll be Josh Wolf.
Josh Wolf, yeah. And that's 3 is enough, right? for you?
Yes.
Okay. All right.
Moving on in my report, I have a listing of new complaints filed this month. Under communications, I would like to skip over the first one as there's some discussion needed on that one. The Show Team Monitoring Committee has requested training from the task force. I believe that's something the EOTC can consider developing and a program for training other commissions.
Sorry, which one is this? 616041?
Actually, this is just a communication, fourth one down, Shelter Monitoring Committee.
Page 319.
Sorry.
There was the Board of Supervisors provided us a copy of legislation that would affect us. I've provided a copy for your review. It's proposed amendments to the Campaign and Government Code requiring commissioners to file behested payment reports.
Okay.
I have provided a copy for your review. It's something that would affect us if it is passed.
Okay.
And I will defer to Vice Chair Hyland regarding the first item on communications.
Okay. And Mr. Clerk, are we? What's typical procedure when the complainant is in the room? Do they get some time to talk?
They are allowed to comment as a public commenter, 3 minutes.
I see. Okay. So, would you like to give us some background? On that?
Yes. Going off the top of my head, several months ago, there was a complaint filed against the public library in regards to the Biblio Commons. The task force heard and adjudicated that matter at that time. After that meeting, Mr. Warfield filed additional complaints with issues that seemed to be duplicative of what the task force has already adjudicated. Due to that fact, this task force decided to not accept those complaints at that time. Mr. Warfield has made another request to us to have a hearing on that matter that we believe has already been adjudicated. In addition to that, Mr. Warfield has requested to file a complaint against the task force. I have been advised previously that the task force should not hold hearings against themselves, and suggested that the Ethics Commission may be the best source for complaints against the task force.
Okay. And I'm just going to add some additional data to that, just from my memory. I think, let's see, Member Wolf and Member Eldon, Member Heinze were probably there as well. I mispronounced the name and she's laughing.
I believe I was there.
Yeah. So this was
this again?
This was to do with the case where the library.
What was it?
They adopted a new, I guess, technology, Biblio Commons, and Mr. Warfield, obviously an interested party, contacted them about, what it was, training on it, and whatnot. There was definitely some back and forth. There was some missed calls on the part of the library. There was one person that was trained in this technology. We spent a lot of time on this issue, and I think at the end of the day, I think there was no violation found because we felt there was a good effort on the part of the library to accommodate his request. They did spend a lot of time with him one-on-one after the fact over the course of several weeks. So that was our ruling back then. I believe after that, Mr. Warfield represented the case. We heard it again. It was deemed to be, or tried to refile the case, but I think Chair Washburn at the time decided that it was duplicative. There was no new information that was introduced for the file, for the case. So we communicated to Mr. Warfield that we would not be accepting it. And I think he's asking a second time that we consider accepting it again. In addition to that, Mr. Warfield wanted to take us as a task force and file a complaint against us. And DCA has advised that we cannot accept complaints about our own body, and the appropriate channel for that is to go to the Ethics Commission. I think that brings us up to speed. Member Wolf.
So, first of all, what is the complaint against the task force?
Mr. Clerk, if you could. Let's see.
Is it in here? Oh, okay.
30, 31, 32.
Sorry.
Just keeps going.
Sorry.
And regardless, I mean, it's not something we can really accept. As you're looking that up, just in summary, it's a complaint against Chair Washburn, the head of the task force, and the SOTF for their actions in regards to non-acceptance of a complaint.
Yep, but violation of what?
It was not stated. The reading on page 329, the complaint is against both Chair Washburn and the SOTF as a whole, as well as any other party that may have been responsible for the denial of our rights under the Sunshine Ordinance.
Yep, but
is there
we are
there's something specific? I mean, it's very vague.
The reasoning behind the hearing denial presumption. We are especially interested to see what the chair may have to say to as the reasoning behind the hearing denial presumed within 5 days of learning of this complaint.
Yeah, I don't know why we would have to go before the Ethics Commission to do that. This is a complaint against us to answer questions as to why we acted or didn't act on something. It's not a violation of any specific law.
I wouldn't see that as a complaint if it's a question. It would just be a question to the
I think he didn't like the answer, and therefore he's filing a complaint. That's how I'm reading it.
Okay, well.
Would we like to allow the...
I would...
Sure.
Yeah.
Yeah,
would
Mr.
you like to
Warfield?
allow him his opportunity to speak on this matter at this time?
Yeah, Mr. Warfield, please. You have 3 minutes to bring us up to speed. So this is public comment. Yeah. Yeah.
Well, I've got other things to say about the item, but I'm Peter Warfield, Executive Director of Library Users Association. The task force is not following its own procedures. In the description that the chair gave, the last two complaints that we filed were not handled as a complaint, were not agendized as a complaint, were not given to any committee or the full body as a complaint. We have filed dozens of complaints over the years, and they've always been given, at least pro forma, the procedural respect and treatment that the task force is normally giving to complaints. And so the last two complaints were simply dumped into the administrator's report. When, at the very late evening, the administrator's report came up, the chair winged it as far as what the procedure would be. There is no procedure for taking a complaint and simply burying it in the administrator's report. Look at your procedures. You have procedures for handling. Earlier, your chair, though it was slightly incorrect, said that the subcommittees consider complaints before they go to the full body. That's sometimes true, and sometimes it goes to the full body. Either way, it goes to the body. If you think something is duplicative, if you think something is inappropriate, if you think that you are not the proper body, for example, to handle a complaint about how your body has refused 2 complaints, I'm willing to hear that from your normal procedural methods. but not dumped into the administrator's report and fly by the seat of the pants rule made up that I get 3 minutes to explain, I don't even know what, the legality of your procedure, whether or not those complaints are different in some way from the prior ones, I believe they are, or whether they are valid. Your law says 6721 that talks about the Sunshine Task Force. The person has a right if they think something has been improperly done, and I don't have time to read this. Basically, on a public records matter and others by practice, you give a hearing. And you haven't given a hearing to those 2 complaints that we filed. The complaints had to do with the library's refusal to accept oral requests for information in a specific case, and a memo that the deputy city librarian sent in violation of 67.22 instructing senior staff not to talk to me about BiblioCommons, but rather to refer all questions to a particular person. That's a unique pair of complaints that should have been heard, and the complaint is about your not hearing them.
Thank you. Member Eldon?
First of all, thank you very much. I understand we don't see eye to eye. I would personally appreciate if you stick to the time limit that you're given out of respect for everyone and what we're trying to offer, since that's what we're all required to do. Rather than going over, which is a habitual thing, I've noticed. Second of all, the particular issue here was that we understood you to be duplicating a complaint, and I am having trouble remembering the details of what you're saying is different about the complaint you resubmitted versus the one we already heard.
First of all, if you're spanking me for going over 5 seconds, my apologies. Normally, a complaint would have 5 minutes to present, 3 minutes to rebut, and discussion and questions additionally, if you so choose.
Yeah, thank you, Mr. Warfield. Thank you.
With respect to the
Mr.
determination of the task force, there was no determination, there was no vote.
Yeah, that wasn't a question. That was just a statement by Member Eldon. Member Wolf.
Mr. Chair, so, here's the thing. Some of us are new to this issue. We don't really know what's going on with it. It's up to us now, I think, to determine whether it's duplicative or not. Obviously, Mr. Warfield thinks it's not duplicative. I would actually suggest 2 things. One is we have an ad hoc rules committee for dealing with such things regarding the bylaws and procedures and things like that. I think it would be a good opportunity to invoke that, to determine of ourselves. I mean, let's look at ourselves in the mirror and see if did we actually violate our own rules or not. And these are internal rules. These aren't Sunshine necessarily, Sunshine Ordinance rules specifically. They're our internal rules. So let's look at ourselves a little bit on that. And then second, have the complaint committee determine whether it should be reheard or not.
I think that's an excellent suggestion, because otherwise it puts the onus on the clerk, who, shouldn't have to be making that call, basically.
Absolutely. Right.
Member Eldon?
Can someone remind me what the exact process is for what people do if they want to have a retrial or whatever of a complaint that we make a decision on, if they want to bring it again? Is there anything that would stop them from refiling the same complaint and trying to get it to us over and over
that
again?
actually is through the chair to Member Holden. That is actually one of the main purposes of the complaint committee, is to determine, is this in jurisdiction, first of all? Second, is this duplicative? And, so we don't keep repeating the same things over and over again. Give the person the time to explain that it is or it isn't. And then if you come up with the same answer, then he'll have to take that as the final end answer of this task force.
Well, not really, if there's always new people coming in who want to rehear things. I mean, I'm not opposed to it, and I'm quite open to it, but like we're, I think, 30 cases behind right now. And anyone who doesn't, there are many people who don't like our decisions for one reason or another, which is like fine and like something we need to deal with. But
it's not staff's responsibility to do that. That's ours to determine whether, yes, to determine that. I don't believe that burden should be put on staff.
I would like to just clarify, staff does not make any decisions on this matter. It is given to the It's given to the chair and placed on the agenda for review by the task force. Staff does not make this kind of decision.
I believe the previous chair, Chair Washburn, deemed this to be duplicative, communicated that to Mr. Warfield, and Mr. Warfield's come back saying he disagrees, and we are where we are.
Right. So my point is if the chair, basically the question is should this body overrule a decision of the chair? That's essentially, if you want to get down to the Roberts rules. If the purview is in the chair, and then an issue is brought up, if the body wants to overrule a decision of the chair, then so be it. My suggestion is let's work our process. It would be actually a good exercise. This doesn't happen that often. Yep. It may be a good exercise so everybody gets an experience early on, so you'll know how to deal with it later.
Yeah. And are you suggesting now to have this before the full task force or the complaints?
No, complaints. I would say first the issue that Mr. Warfield has with the procedure go before a Rules Committee. Rules Committee only meets when it absolutely needs to. So I would say invoke the Rules Committee.
So there's no endless loop of the same things getting brought forth and then debated and then retried. I don't know. We followed our procedure the first time, and now we are. If it was the chair's decision then, and we followed the procedure that we had set up, and now we are going back and saying, let's reconsider that whole procedure.
I didn't hear that there was a procedure. I heard that the chair made the decision.
Actually, it was placed on the administrator's report, and the full task force was able to review the matter. It was not an action item, so unless a member of the task force made a motion to accept the complaints or something to that effect, it was not going to be accepted. So
let me ask Mr. Warfield a quick question, if you could approach. What new material are you providing us? And please keep your answer brief.
It's all new. Everything. And there was no consideration by your rules by the task force. It was dumped. I never heard from Chair Washburn nor that she had made a decision. It was placed completely outside of your complaint procedure and your bylaws. There was no decision made by the task force except silence.
Okay, that'll
silence.
Do. Thank you. All right. So like I said, so my memory, and unfortunately our minutes are, especially when there isn't a motion, it just says no motion. It doesn't get too much into the discussion. We spent a long time on this, and we had members of the library up here, and the person that was designated to lead training on this, I think the library said direct all questions to her because she's the only one qualified to help members of the public with this. Mr. Warfield got a lot of one-on-one time with her, phone time, some missed calls, eventually connected. If I think they probably did above and beyond what they should give, time given to any member of the public, which after all, Mr. Warfield still is, even though he's the director of Library Users Association. So I feel like he felt he didn't get his fair shake, and that's what this is all about. And his attempts to repackage it, I think, were seen as duplicative by the previous chair. I was involved in some of those communications. I agree with that. But we could, at Member Wolf's suggestion, put this as part of the complaints committee as one of the agenda items, possibly even as early as June 21st, and that could be considered as a good thing to get your teeth into. Member Wolf?
I would just say in the previous 7 years that I've served on it, we've done this countless times where people didn't like their decision or they come with something else. And it was the complaints committee that would determine whether it was new information or not, and not burden this meeting tonight with that.
So I think at this point,
that's basically what I'm asking for.
all right, I think that's a good suggestion. Mr. Warfield, would you be okay with that?
I'm not sure what the complaints committee would do, except, again, there's no procedure. You don't have this in your complaint procedure and so on.
I'll tell you what they're going to
So
do.
what-
They're
what
going
if
to
they
evaluate
decide-
whether your new items are duplicative or not. So if you have any changes to that between now and then, please get it to the clerk. What you're, try and summarize very succinctly what it is. I may even drop in on that meeting.
That would be great.
And that meeting would be June 21st, if we have time to agendize that. Okay, so let's put that on there as part of the...
And I just wanted to clarify, we're not requiring the respondent to appear at this meeting.
Agreed. Yeah, this is just to hear...
Is this going to follow the complaint procedure so that if I disagree with their decision, I can bring it to the full task force? Because part of the problem is there's no clarity as to what is duplicative, what aspect is considered duplicative. I'm stabbing in the dark. I say it's new, you say it's not. So in what respect is it?
I'll tell you
This has never happened before to me, never in 20 years.
Yeah, let's have that complaints committee, and I will defer your answers to next month's chair, whomever that might be. Because I don't know.
So it'll be handled as a complaint, as two complaints?
Not answering that. To be determined. It will go to a complaints committee as a first step.
My understanding is that the matter will go to the complaint committee for determination as to whether or not to accept the complaints, to determine whether or not these two new complaints are duplicative of the items that have already been adjudicated by the task force.
And they can make a recommendation to the full task force.
Just make it easy. Just run it through the same process. It doesn't matter.
Yeah.
Just run it through the regular complaint process. It'll come to the complaint committee. They'll hear Mr. Warfield's testimony to show that it is not duplicative.
They'll make a recommendation.
They'll make a recommendation of whether it is or not.
And it will come to the full task force for how we're going to treat their recommendation. Right. Okay, thank you. Member Wolf, briefly.
If we're following the complaint process, the complaint committee process, then the respondent would need to be there in order for that whole process to still be uniform to that process. Otherwise, we are creating a different process to look at this.
Do we need to notice them and then invite them and tell them that they don't necessarily need to be there? Would that be the correct?
You got 20 days.
Yeah.
So, yeah, notice them.
Yeah, might as well notice them. That would be correct, I think.
I would like to put it in the subject matter that it is reviewed to determine whether or not it's duplicative or not.
Yeah,
so that they are not preparing to hear the item from scratch.
Right, and yeah, you can, and if they have any questions, tell them that we're...
Yes, and I would you like to make it voluntary for them to show up or not?
Just notice them. Just notice them. Let them determine whether they want to show up or not. Okay.
Is that adequate notice if they need 20 days and tomorrow's June 2nd?
Yeah, I believe so.
Well, if tomorrow's June 2nd and the meeting's on the 21st.
I'm not sure what you're referring to.
No, I just was saying that there's 20 days. It's enough time.
Oh.
Yeah. There's no requirement.
To get the agenda out. Don't worry.
Just saying it's not next week. It's like
no legal briefs necessary.
Yeah.
I will work with the chair of the...
All right, can we take that without objection?
May I make a comment?
Mr. Worf, I'm sorry, we're out of time. We need DCA Cole here for the next item, so you'll have your chance.
It's going to be a complaint. Is it going to be a complaint procedure or not?
Yes,
is it going to follow the complaint?
I just said that. Yes,
it will
be a complaint procedure.
Okay, so
for the purpose of determining whether or not it is duplicative or not.
Right. Okay.
That's not hearing the complaints. That's putting me on trial to show that it's different from a previous complaint.
Correct.
It's up to you to decide if it's duplicative. That's fine with me.
The complaint committee process will determine whether it is duplicative or not. If for any complaint that comes through the complaint process, I think it is not helpful to specify that the purpose of that specific hearing is to determine whether it's duplicative or not. The outcome will be whatever the outcome is.
I will work with Chair Harlan on this matter. because that just brings up other issues.
What other issues? Let's get them out. What are the issues then?
DCA Cola? No, I know. Hold on one second. Let's just notice it. It's going to go to Complaints Committee. We're going to aim for June 21st in interest of, hearing this quickly and notice both parties. Keep it as simple as that.
Okay.
All right. Okay. Can we buzz through the remaining?
There's only the last item on
Okay.
the agenda, item 14, announcements, comments, questions, and future agenda items.
Okay. Member Wolf, you had something for
So
DCA Cola.
with regards to the case that we had just heard around Jeff Lewis versus the SFPD, a little concerned that we might run into some possible litigation issues. And I'm wondering if we should have discussion, whether that is enough, even though it wasn't mentioned here, I'm just kind of feeling it, whether maybe we should have a closed session to discuss it, considering that there may be some liabilities.
Well,
Member testify.
It looked like Mr. Young was able to show that Mr. Lewis provided the document himself.
Okay.
And so I feel like I don't have that much of a concern.
Should we memorialize that in some kind of way? Just to
if you'd like, also, I remember I think it was a few months ago, we amended our complaint procedures to specifically state any documents that you submit to us, we will not be responsible for redacting, and it will be a matter of public record.
Okay.
I think we cover our bases there, but I also think that, whatever ends up, that agenda is already on the internet. It's already on the website. If we could redact it in its entirety, retroactively, I think that'd be just a good precautionary measure.
The problem is, it's pretty redacted, but where it follows, can you change the order, page order?
I don't think that'll even make a difference. It's pretty obvious.
Yeah, there's no getting around it. The implication is there already.
Yeah.
I'm just saying if we memorialize that we received that document from
him.
I will include it in the minutes.
Yeah, I would just say that kind of gives us a little bit of cover on that if anybody says anything.
But we don't want to, by memorializing, we don't want to, say, everyone, look at this. So can we say certain materials how can we do it without?
Certain, I would say something along the lines of certain materials.
Personal materials were provided.
Certain documents that were disclosed to the task force by the complainant contain sensitive material that the complainant later did not want revealed and has since been removed.
We're not removing it.
We're not removing it, though.
Has since been redacted further.
Well, you're not going to remove it, but you can blank out the page or put classified over it or something.
Oh,
right?
that's right. You're going to drop it into another folder, weren't you? A confidential folder. Can we do
So
that?
the page still exists, but the material on it will be completely blacked out.
We need to get into that. Yeah. Remember, Wolf?
That's why I'm asking.
I'm a little concerned of drawing more attention to this when the reality is that there's probably no one searching for it. In terms of our legal liability, I don't know whether you happen to know the information on this, but I know as a reporter in the past, I've been able to just, people being 5150 has been a publicly accessible piece of information when calling other police departments. I've never done that with the SFPD, but I've dealt with that with other jurisdictions. Mm-hmm. And so I think we should look into whether or not the fact that this incident occurred as it did, what's been reported in our paperwork, whether that's already publicly accessible information, and if it is, then we should probably just sort of move forward and be done with this.
All right.
So perhaps if you could forward to DCA Cola what you received from him, and you could perhaps memorialize.
Sure. I'll document it in an email to the task force.
Okay.
Sure.
I think that's a good first step.
Okay. Thank you very much. Appreciate that
Thank you,
advice.
Member Wolf.
The second question I have is, are the committees audio recorded?
Yes.
Okay. And to get to Member Moss's issue around dealing with abusive complainants.
I had
Microphone.
So I was just curious what our responsibility is in regards to the code of conduct, and without making a judgment one way or another whether what Mr. Petrella said was abusive material, verbal abuse or not, the recipient seemed to have indicated that he felt disrespected and insulted. And so my question is whether there's any obligation for us to do anything, because the code of conduct does say we're, supposed to discourage that at the very least.
Where is that code of conduct that you're referring to?
It's in the packet that was sent to us. So actually, I have it in front of me. Actually, it's number 4. It says all members of the public, colleagues, and staff.
It's item 5.
Individuals who verbally abuse or physically threaten members of the general public, city officials, or other staff members shall be discouraged, reprimanded, and removed if needed from public meetings and city facilities. Is that what we're talking about here?
That's what I was curious about. Which
document is this?
This is a city.
This is what I signed today.
You signed.
And we all signed it today. So
it's from the whole. It's citywide.
Citywide.
Okay.
Yeah. Citywide.
So I just wanted to make sure I was following procedure with that.
Well, Robert's Rules basically covers that too, just as basic parliamentary procedure. If somebody's disruptive in a meeting, if they're making direct comments to any member, they should be addressing all comments to the chair. That kind of stuff already applies. This code of conduct just specifies more specifically, if people are being abusive, call the sheriff.
Right.
It's not, we've done that before.
What about for emails, though?
So that was number 4. It stated all members of the public, colleagues, and staff should be treated with courtesy, respect, objectivity, and fairness. No one shall be willfully attacked, defamed, or slandered, nor shall comments be made that are disparaging of one's age, ethnicity, background, gender, race, religion, sexual orientation, or physical ability. So my question then was, did that happen in
slander
in some documents? Yeah.
Member Wolf?
I mean, my interpretation of that when I signed it the first, I didn't sign it this time, but in reviewing it, is that that's our duties as city agents to follow those codes of conduct. It is not our duty to ensure that the code of conduct is being enforced
or report.
And so I think it's not our purview as the Sunshine Task Force to be like reprimanding Michael Petrellis for harshly worded emails.
Mm-hmm.
I just wanted to make sure I wanted to raise the question, and I wasn't saying whether we should or shouldn't. I just wanted to know if we needed to discuss it.
Very good. Good point. Any other topics of interest?
So we kind of just went over it briefly in the. It was just mentioned in the last agenda item about this behested payment legislation, and I did learn about that today, and so I wanted to just inform people what I learned, if that's okay.
Sure.
So the reason this is important to members of commissions across San Francisco is that who's familiar with the behested payments for FPPC? So if you're a state senator and you ask lobbyist A to donate $5,000 to your local YMCA, you need to report that you asked him to give $5,000 to your local YMCA. So this would apply this to members of boards and commissions, which kind of sounds okay. I'm finding it a little bit problematic because the way that it's phrased is that if you do direct or indirect solicitation, you have to report donors for $5,000. So if you were a member of this board and you worked for Mother Jones Magazine, and every article that you publish has a donate to Mother Jones in the corner, you might have to disclose any donor to Mother Jones who donated over $5,000 because you indirectly solicited and that was a donor who's more than $5,000.
I have a question. Isn't that in the course of your duties as the commissioner?
So I spoke to the city attorney, deputy city attorney listed on the ordinance, and that is what I explained this scenario because it actually applies to me as well because I write blog posts for Electronic Frontier Foundation. We have a donate link on every page. Would that count? And he said yes, as currently phrased, that would apply.
And
it sounds ridiculous, but that is what I was told.
is there any, so is this law, is this state law?
So it'll be a city ordinance.
Be city ordinance. It is. Microphone.
It is under state law that way. My boss has to follow this, and I also follow this because of that. And so, if I'm trying to raise money for a charity and I send out an email blast, I need to make sure that nobody who comes before me at the Public Utilities Commission is included on that, because they might feel that if they donate, they'll get a more favorable opinion from me. And so yours is a bit more passive, and so I understand your concern, but it's definitely been an issue at my workplace where that has happened. So
Member Cañada.
Just for more clarity, I was the treasurer of a neighborhood group. I'm not on the board anymore, so I don't do that. But if I ask people it's a not-for-profit, ask people to become members and solicit them to become members. Does that fall?
If they do more than $5,000, yes.
No problem.
And it doesn't matter if you're on the board or not. If you try to raise money for any charity, then that would apply.
Okay.
But the thing that I find that may be problematic is if you work for SBJ or you work for any nonprofit Center for Investigative Reporting, something like that, that even if you are not a fundraiser for it, you could come into indirect fundraising because of it.
Very interesting.
So this is just becoming the oh crap, how does this work thing? But I build campaign websites. So they're all involved in making money, and I don't even have access to the donations, and they're usually not even in this state.
Is your name listed on there? The thing would be if your name was listed on there and someone was that Mr. Warburton? Warfield, and he comes before us a lot, he'll say, it'll look good if I donate to this campaign because I see that Josh Wolf's name is it.
Yeah, the only way my name is listed is through the public filings that they paid me to build the website.
So that's different.
So what could run to problematic is that if you write a piece for a nonprofit publication that has a donate button on it, that may be, but that's even if you're not even an employee of it or anything.
But it wouldn't apply to your situation. If your name isn't on there, then there's no way that someone is seeing that and thinking that it's going to benefit them by donating.
What about the name of your web firm that does the development that gets put at the very bottom of the website?
They would have to know that is the company of Josh Wolf. So it's more...
The company name is... Well, wouldn't that apply in this case then if it's Mother Jones and not...
No, but see, with him, his name is in the byline. So people see that and then they'll know, he's someone who's on the Sunshine Ordinance Task Force.
So could you get around that by putting... Sorry to interrupt.
It would be him publishing under a different name or him not including the donate button on any articles that are associated, but that's his whole job.
Or EFF staff.
Yeah, or under EFF staff, but that...
It all depends, but it is problematic. There is the person, if you have questions about it, Lee Hepner is the one to call, apparently. So I just wanted to put this out, and that this may be something that other boards and commissions aren't aware of and may have significant ramifications.
So I have another question. Yeah. When we do our Form 700, it's specifically a statement of economic interest within the jurisdiction of this body. So I work in San Rafael, and my name is on our website there. I'm their CIO. Okay.
Sorry, I'm. It's very late, and I'm missing your.
So my point is that the jurisdictional issue. Then, how does that apply?
I don't think it matters. I think if it's somebody, if you have a charity in, Japan, and somebody's donating to your charity in Japan, it probably still applies.
Okay.
I'm not a city attorney.
I'm just saying that it's one thing. It's one thing if it's within the jurisdiction of the city and county of San Francisco. That's the way Form 700 for what we apply is applied to us. That's what it means. So the question then is that out the door with this?
This is the
ordinance?
behested payment. This is separate from the Form 700.
No, I understand that, but it's still an economic interest.
With the behested payment, the concern is that the person donating is someone who may come before you at any point. It's hard with the Sunshine Ordinance Task Force because it's such a broad issue. It can cover any kind of agency.
No, not any, just only within the city and county of San Francisco, right?
But But anyone can bring the complaint on an like someone in San Rafael could bring a complaint against a city and
it's true.
The city and county of San Francisco.
Could I suggest that we open a agenda item for this, and Member Moss can lead the research into this? This would be something.
Sure.
To come back and let us know.
As I understand
That'd
it,
be
if, Victor, is it? Sorry, I'm probably breaking protocol, but they are seeking feedback on this? Is that?
It was provided to us as a FYI so that we are aware of it.
Okay.
By who?
By the clerk of the board.
Okay, all right. So it probably wouldn't, if you wanted to do a little research and then kind of give us an update and you could present it to the task force.
Sure.
It'd be good to have that sort of in our files and for all our edification.
Assuming it's not an ordinance by then.
Member Wolf?
So who is actually bringing this forward to the Board of Supervisors? Who's sponsoring it?
Did you say Member Hepner?
It's Hepner. He's a name
So it's
for
Aaron Peskin.
Peskin,
So
yeah.
Peskin's bringing it forward. Okay.
Yeah.
Okay.
I don't have anything else.
Anybody else?
Move to adjourn.
All right, guys. Good meeting. Thank you, everybody.
Good meeting, guys. Good meeting, guys.